environment, which is also very important. And in terms of the challenges, we all know that technology moves at such a fast pace. It moves faster than our traditional legal education, and in many cases, even faster than legislations and regulations. And so this means that as lawyers, we need to develop a curiosity to understand the technology, as well as the discipline to keep up with the regulatory developments, because those move really fast. And we also need to have the practical ability to translate complex technological issues into sound legal advice. So for lawyers entering this space, I know that the landscape can sometimes appear overwhelming. It was like that for me when I first started. And you're probably wondering, what exactly does a technology lawyer do? What kind of laws and regulators or even regulations should we understand? How do these telecommunication regulations intersect with technology practice? And what does a typical technology transaction look like? These are some of the questions that I'm hoping, and we hope, that this symposium will begin to answer. And I'm saying begin deliberately because technology law is very vast and it is constantly evolving. So just having this symposium alone is not enough to answer all these questions, but it is a good introduction, and it can provide something equally valuable, which is a foundation. And this foundation is important for lawyers who are curious about technology law. It's also a good foundation for any practitioner who is looking to expand their area of practice. And more importantly, it is a good foundation for all of us to appreciate effective technology and what it requires, specifically the understanding of the environment in which the law operates. And so I want to encourage each and every one of us present to engage actively with our speakers. Ask questions and challenge assumptions, and please do not be the person who is afraid to ask the most obvious or basic question. After all, the whole purpose of this symposium today, especially with the title Technology Law 101, is to make these complex discussions more accessible. Before I leave, I would like to express my sincere appreciation to the leadership of the Nigerian Bar Association section on legal practice, as well as the Technology, Media and Telecommunications Committee for creating this platform and for recognizing the importance of building capacity in this rapidly evolving area of practice. Once again, I would like to thank our general sponsors, Law Corridor, for their sponsorship and the support of this symposium. To all our speakers here present and those online, our panelists, our moderators, thank you so much for sharing your time, your experience, and your expertise with us. I hope that by the end of today, we will all leave here with a better understanding and a clearer understanding of what telecommunications and technology practice is all about. A greater appreciation also would grow in our minds for this field of practice, because in technology law, really, the questions are constantly changing, and the lawyers who will be best positioned to provide these answers are the ones who are willing to keep learning. So once again, welcome to Technology Law 101, Introduction to Telecommunications and Technology Practice. I wish us all a productive, insightful, and engaging symposium. As we move on to the next item on the agenda, may I invite us to please stand for the national anthem. Thank you very much. You may all be seated. I'd like to call on Mr. Usman Chamo to give us the NBA prayer.
Good morning, distinguished ladies and gentlemen. Kindly rise for the NBA prayer. No, I have it here. Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors so that we shall continue in all humility to glorify the name and do that which is right and just for our profession, its members, our fellow men, and our country. Amen.
Amen. Thank you so much, Usman. I'd like to call upon Ms. Kehinde Habibat Ali Imam. She's the Director, Administration and Corporate Service at Law Corridor. She will give us the Building Safety Protocol announcement.
Good morning, distinguished guests. Before we commence, we have to, please be informed that this venue has 2 emergency exits, one in front and one at the end of the hall. In any event for an emergency, kindly remain calm and pass through the nearest exit following the directions of the event officials who will be stationed outside. For your convenience, the ladies' restroom is on the first floor, while the men's restroom is on the ground floor, passing this exit. Thank you.
Thank you so much. Next on the agenda, I'd like to invite to the stage the chairman of the TMT committee. His name is Fernandez Marcus-Obiene. Please, a round of applause for him as he comes on stage.
Thank you all. Good morning. Please put your hands together for yourselves. A while ago, I was at an event, and the MC of the event told us at the event that a lot of times we spend money to go to the spa, to do massage, so that we can get our bodies in good condition, to make our hearts better. He said that when you clap, the pores and the veins in your hands go all the way to your body to massage your body, to give you that thing that you pay thousands to hundreds of thousands of naira or dollars to get. So please, when you clap with all seriousness. So can we put our hands together for ourselves again? So because we're starting a little late, I'm not going to do so much of the protocol. Later, the protocol will be established. But I'd like to begin by saying a very big thank you to the people that made today here possible. When you look around you, you see Mr. Edet. Okay, Mr. Edet is not here yet, but he's on his way. You see Mrs. Ali, you see Mrs. Ayandele, you see Mr. Bello. Where is he? Now, these are people that work every day in the field of technology and law. So they don't have to be here, but in the case of Ayandele, she flew in from Lagos to come and have us here. I'm grateful to each of them for coming. I'm also grateful to the executives of the TMT committee, as well as the best committee ever, the planning committee for this event. And most importantly, I am grateful to the indefatigable and most beautiful Mrs. Folashade Ali, SAN. She is the chairman of the NBA-SLP, and she and the leadership have left no stone unturned in making sure that we succeed. I'm very grateful. We are very grateful. I'm also grateful to the law firm, and I will discuss that a lot more, but we're really grateful for the law firm because they're giving us the best hospitality you can expect. Now, a few years ago, somebody walked into my law firm, said Aka attorneys. He ran a small technology company that dealt with businesses in Nigeria, right? But he was using a European technology, and it worked very well, very fine. Unfortunately, at some point, one day, it just stopped working. So he came to the office and he was complaining. He thought maybe it was a finance dispute. So he came and he was expecting us to talk about money, to go and send an invoice to them or something. And then when we reviewed the situation, we realized that it wasn't money that was the problem. You see, in the EU, they use the GDPR. Now, the GDPR is effective on all technology companies. It requires their technology companies, or not just technology companies, companies generally, to adhere to certain standards of data protection. Now, and the company also insists that all their partners adhere to those same standards since they are required to. So unfortunately, that my client that time, well, he became my client that day, had not met some of the requirements. And so his business was shut off. He was losing money. His clients were angry. Now, let's hold on to that man. I'll come back later to him. So why are we here? The people that brought you here, let's talk about why you are here. I mean, the people that brought you here. You are brought here by the Nigerian Bar Association section on legal practice, technology, media, and telecommunications committee. It's a mouthful. So let me just explain to you what we do. We try to help Nigerian lawyers to be good at law, the law of technology, media, and telecoms. Because in school, most of us were not really taught as much on telecoms and technology. And even in practice, unless you are like Ms. Ayondele or Mrs. Hamu or our speakers who were forced, although they might have liked it, but they were forced into the practice. But you really don't learn it. So what we do is we try to ensure that we have programs as much as possible. We have weekly webinars, and then we try to push for policy. We also, every now and then, as we're trying to do now, try and get people in a room so that we can talk and network while we're doing it. So, of course, in my work as in the justice sector generally, we see that our lawyers are quite smart. So it's not that they're not smart. But when it comes to technology and telecommunications, it appears that they're working in a dark room or working from a dark room. But the thing about darkness is that somebody can switch on the lights and everybody will, and then you get to see everything. So let us have a small light moment together at this event. Now, I don't want to go in depth because all these are people here will come and tell us a lot of things, and I don't want to take too much time. But there are 4 primary laws that relate to technology and telecommunications. We have the NCC Act. There are others that I'm not going to mention. We have the NITDA. We have the NDPA, Nigeria Data Protection Act. And then we have, of course, the recent Cyber Crimes Act. There are a number of them, Wireless Telegraphy Act, etc. And then underneath these laws, there is a bunch of other regulations that are involved. Now, of course, my promise to you is that by the time you leave this place, you at least have an idea of those basic things. But while you are here, please don't think that you have to cram everything. Just be calming down. Everybody should be calming down. You don't need to cram everything. But you just need to know that technology and telecommunications laws, which are 2 similar but different aspects of law, are its own field. It has its own referees. It has its own laws. And it's not just local. Remember the story I told you? An international, something that happened in Europe affects us because data travels everywhere. So don't make the mistake that my client's former lawyers made when they didn't advise him. I shouldn't say that, but don't make that mistake of not knowing. You should know. Now let me return to my friend, the client whose business was lost. Eventually, we sorted him out. We brought him up to standard. We sent emails. We spoke to the right people, and we got him back. But that's not the most important thing. For everybody that manages to get their problem solved, there are about 100 outside who never get their problem solved. So for us, every 1 person that we train here, we're actually helping 100 people outside to solve their own problems. And that is what this committee is for. That is why we're here. Thank you very much. Good morning. A clap, I'd not like it.
Thank you so much. We're moving on to the next item on the agenda, which is a special remark from our generous sponsor. When I started my introductory remarks, I talked about the generosity of our sponsors, Law Corridor, and Fernandez also alluded to the same thing in his remarks. So you know that we're not capping. So to give us the remarks, I'd like to call on Mr. Henry Kelechukwu Eni Otu. He's the managing partner at Law Corridor. Please give him a round of applause as he comes on stage.
Good morning, everyone. Particularly, let us say good morning. It's with pleasure and great honor that we welcome the section on law practice, Nigerian Bar Association, to Law Corridor. Fortunate enough, by our building and facility, we've been able to provide an avenue where learning and experience could be gained. It's a great privilege to host this event today. As Law Corridor, we have a team, particularly we have a department which is focused on the issue of telecommunications. So I believe that is a mutual relationship between the Law Corridor and the Nigerian Bar Association. And it's one which we believe will foster more unity, more experience, and more knowledge based, particularly within the specific area of the telecommunications law in Nigeria. We hopefully promise to continue to provide ourselves and make ourselves available for future events of this nature, particularly towards fostering education in Nigeria and particularly law practice in Nigeria. We are lawyers and our only work is law. We have no other business. The only thing is that we do law in form of business because law is business. So welcome everyone and thank you, and do have a great event today. Thank you.
So our only work is law. How many of us agree that that's the only work we do? Okay, not a lot of hands. Mr. Henry, I think your people do not agree with you. Moving on to the next item on the agenda, it is my distinct honor and privilege to welcome on stage the chairman. I beg your pardon. I don't know why we keep doing this. I think that at this point in time, we have so many women in positions of authority that we need to agree that we should stop using chairman as a generic term. We can use chair lady, chairwoman, or better still, chairperson. So please allow me to introduce the chairperson of the Nigerian Bar Association section on legal practice to give us her opening address. Please give her a round of applause as she comes on stage.
Good morning. Good morning, everyone. It's indeed a pleasure and a privilege to be here. First of all, I would like to start by recognizing the senior advocates that are here. Some are joining online, I understand. The Abuja Bar. Thank you very much. I mean, this place is, the hall is packed full. I understand there are also some people joining us virtually. To our host, Law Corridor, I don't know what to say. They've said it all, but I will say what I see. You know, when you talk about modern practice of law, I came into these premises, I was extremely impressed. I didn't know where I was coming. So when I saw, I said, where is Fernandez bringing us to? But when I got here, I was more than impressed. This is what law practice should be about. And we, the old ones, would like to emulate you. From the way we were received. You know, they said the way you are dressed is the way you are addressed. Every lawyer from the gate were extremely impressive. All of them are properly dressed, even the ladies. You know, so I really want to thank you, first of all, for that standard. And that's the standard that we're looking for. And we hope that we'll be able to achieve at the section on legal practice. The bar really needs people like you. Rules of professional conduct is so, important. And it also emphasizes on how we dress. Honestly, that was, if you ask me what did I see here first, that's it too. I saw technology at work. We're here. When I first of all came and I said, am I in a cinema? Truly, you will want to learn. You're in an environment where it's conducive. I can understand why they have 45. I had to ask him 3 times, how many are you? 45 lawyers. This is what, law firms are struggling to have. You're really like, you've become like an Alukano, Yebode, Ebawa, Nigodalo. You will go places because that is what we're looking for. I've seen quite a few of them today, from Pelumi to Mr. Bello. There's so many people I've met, and everyone impressed me. So there's something they're doing we should emulate. And I'm so happy that Fernandez brought me here. He called me, Mr. Ali, won't you come? And I said, I'm very busy. But later I thought about it. If someone, and I would like to acknowledge, and I'd like everybody to join me in acknowledging Fernandez Marcus-Obiene. He's the chairman of the TMT. When we set up that committee, I think it was the year before mine, Boma Alabi's regime, then he now called me and said, Mr. Ali, I'd like to add another. I said, if it's you, we don't have a choice. It's the most effective committee, and I say it, those sense of responsibility that we have at the section on legal practice. Every Thursday, unfailingly, they have a webinar. And what are they trying to do? To give back. He doesn't need to do it. If all of us can do the same, Nigeria will be a better place. He's gone out of his way. He's brought people that even I'm wondering, Fernandez, how did you get DG this, DG that? Everyone, he brings them to come and teach us, to come and nurture us. So I'm not surprised when he finally decided to have a physical meeting. It's the first SLP is having. We've all gone virtual. But there's something in meeting, camaraderie. Today, I came and I said, this is it. If I didn't come to Abuja, I was debating on moving my conference to Ekiti. And when I came here, I said, if I have Mr. Henry, I have Franklin, I have everybody saying they can do this for me, what am I looking for? I've been looking for LOC. I found everything today. That is the essence of physical meeting. Virtual can never take the place of physical. And Fernandez, I thank you again for being the first committee that we have to have a physical meeting. So I know I'm supposed to do a welcome, and I'm not going to take time because at times I know I go on and on. I'm not going to do that today. For everyone that is here, especially our resource people, when I spoke to Antonia earlier on, she said she came from Lagos. That is commitment. We thank you so much for coming all the way just to give back to us. We continue to thank our sponsors because that's really like, sponsorship in some way. All our resource people are here. My plea to everyone, don't take this meeting for granted. When they talk about basics, technology law 101, that means that the basics of technology is taking over. Even at times now, you can't draft. Before you tell your lawyers to draft something, in 2 minutes they're back. Somebody has drafted for them. You tell them to write opinion. Opinion is written. Award is done. Judgment is done. Half of the time, 0.1. Because, they have not done their research. At times, I said, ChatGPT, you are quoting ACA, Arbitration and Conciliation Act. We've moved to AMA. Oh, you're right. I'll say, okay, thank you, my darling. We've now become friends. It's unbelievable. One day, I went on and I said, no, that's not what I want. I said, no, that's not what I want. Then later on, I said, I'm tired. He said, good night, my dear. I said, good night, see you in the morning. That's how technology has moved on. And if we, can adapt to technology, why not you? However, please, technology can never take your brains because you have to use technology. Technology should not become your brain because you're all going to go dead. Because, dementia starts from you not thinking. So please, technology is here to stay. We must learn how to use it and use it effectively. And that's why we continue to thank the team. The executive committee, the management committee of TMT have done very well. Damilola and all of you, kudos to you. We're so grateful to this committee. And to everyone that has come here today, is the beginning. Now, for those who do not know about us, MBA section on legal practice, we are the section to be part of. Please join us. we are going places, and we've really tried to impact. That's what we're for. We have so many committees. Every committee is trying to impact. We want to change that narrative that we're about just litigation. Technology, there's litigation in it. ESG, there's litigation. There's so many committees you can join. Please be part of MBA section on legal practice, and let me not tell you, but please just come and experience our conference next year, and you will be very impressed. Please, before I hand over to the moderator again, I'd just like to thank Law Corridor for opening your doors to us, and for all the speakers and for those who have attended today. Thank you. I therefore declare this symposium open. Thank you all.
That was a really, really wonderful welcome address. I think she did a very fantastic job at setting the tone for this event and for the discussions that we're about to have. So moving on very quickly, I want to introduce to us the next speaker. She's going to be the first speaker in terms of the knowledge sharing. As you know, a symposium, the whole point of a symposium is to share knowledge. So let me tell you a little bit about Mrs. Saadatu Hamu Aliyu. She's the managing partner of Hamu Legal, an Abuja-based multidisciplinary law firm. With over a decade of experience, she advises clients across corporate commercial law, national security, regulatory compliance, policy, governance, and emerging technology, with expertise spanning sectors including energy, fintech, real estate, project finance, and asset acquisition. She's also a prominent voice in Nigeria's technology and governance ecosystem, contributing to national and regional conversations on law, policy, politics, and economic development. Mrs. Saadatu is an associate fellow of the Nigeria Leadership Initiative and an alumna of the Nelson Mandela School of Public Governance Emerging African Leaders Program. She holds an LLM in National Security Law from Georgetown University Law Center. Ladies and gentlemen, please put your hands together for our first speaker for today.
Thank you so much. Good morning again, everyone. Thank you so much, Chidera. Even me, I would want to meet myself when you introduce me, this way. I would echo the chair and give a very, very, I think we've given them enough round of applause, but I went to my niece's school and they taught me something. They say that they do counts for claps. When they do one, it's atama. I can't remember the rest. But when it's great, you then give them 10 claps. So I'm hoping we'll all be together to give the organizing committee, our sponsors, and every member of the section on legal practice that 10 clap, which I think they call atama. But we can start now. So let's do it 10 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If I do well, you can also give me a 10 afterwards. So again, my talk today is supposed to be on technology and telecommunications law. So, but I shifted it a bit and I said, when we talk about telecommunications, we think of connectivity, right? How do I connect from one person to another? So I titled this my conversation, Beyond Connectivity, the future of technology and telecommunications law in Nigeria. The next slide, please. So, when last did you use the internet to do your job? Anyone? When? I believe everyone in this room used it this morning. So clearly, Technology is in almost every part of our lives. I will give you a short story. In 1999, during my short stint in boarding school, I only stayed there for maybe about 2 terms. Speaking to my mother was an if I'm lucky event. This week involved me waiting for Sunday to come. I would visit the phone booth. I would then queue up, hoping to get a chance to sort of put in my card to make the call, but beyond that, hoping that it would even actually connect. Today, that same conversation would happen over WhatsApp or FaceTime. In fact, I asked Sophia to give me the link so I could give her to join this conversation. I'm hoping she's linked in. So hi, Auntie, if you can hear me. Join me in saying hi to her. But in just about 20 years, Nigeria has traveled from using the phone booth to artificial intelligence. The chair made reference to her darling when she was giving us her welcome remarks. But the reality is, this transformation in Nigeria did not happen because the technology alone improved. It happened because law, policy, regulation, and innovation all moved up together. Can I have the next slide, please? So my colleague Opelwa spent a tremendous amount of time to work on this slide. So I would really need you to please make sure I use it. So as lawyers, therefore, if the entire ecosystem, you know, the law, the policy, the innovation, and the economy evolved at the same time, then our role as lawyers then is no longer to just understand the technology in itself, but is on even something more important, the legal infrastructure that makes the use of the technology possible. My central argument today is simple. Technology and telecommunication law is no longer merely a specialist area of the practice of law. It has become the legal infrastructure upon which Nigeria's digital economy will be built. Then moving back to my initial story of the phone booth. Can I still have that slide, please? Because he also didn't know what the phone booth looked like. So this was the phone I'm referring to. So before we talk about even where we are or where we're going, I think it's important to talk about where we're coming from. The history of Nigerian telecommunications, as we all know, started with NITEL. But in preparation for this symposium, I do understand that before NITEL, it was even called Nigerian External Communications, which was NEC. But then something fundamental happened in 2001. There was a liberalization of the telecommunications sector and the licensing for GSM, which changed the trajectory. But the reality is that liberalization, it was not an event, it was a journey. The process began in 1992 with the establishment of the Nigerian Communications Commission, which gradually began to open the sector to competition. However, the defining moment came when the NCC conducted the landmark GSM license, where a number of operators bidded for it. But in reality, the reforms that followed subsequently is the reason that we are all here today and enjoying the privileges that we have today. The Nigerian Communication Act was now passed in 2003, and it is today the foundation that has provided for us a stable legal framework that encouraged continued investment and competition. I was not even in the university at the time, but looking back, I believe at that time it would be very easy to say, you know what, GSM changed the communication, GSM changed the world. But to me now, as a lawyer, when I look at it, I say the liberalization of the telecommunications sector in reality was not was not an economic reform in isolation. It was a legal reform that gave birth to an entire new economic ecosystem that we're all enjoying today. That act alone created the foundation of what we see today as the fintech companies that we have, the PayStack. It also created the foundation for the first e-commerce companies that we know, like Jumia and Co. So when you look at it as a whole, technology has then stopped being merely a communication sector. it became an economic infrastructure because it challenged and changed how we not only communicated with each other, but even operated as a country. So therefore, this brings me to my first proposition. If telecommunications is no longer a sector, then I also argue technology is also not an industry in isolation. Technology is infrastructure. Today, almost every business depends on technology. Hospitals rely on technology. Banks rely on technology. If you don't receive the alert, nothing will happen. In fact, when you make the payment and they don't receive the feedback on the MoneyPoint app, nothing can move forward. So again, even in our law firms today, we all use different type of tools, right? But the most popular one that we do for referencing of cases is Law Pavilion, amongst other things. So the reality is, the question is not whether you are doing technology law or not, because we are all already in it. So if technology law is infrastructure, so what does the future look like? When we talked about infrastructure maybe 2 decades ago, we're talking about roads, bridges, houses. And when we're talking about even the technology infrastructure at that time, which it still existed, we'll be talking about spectrum licensing. I don't want to go into Antonia's conversation, interconnectivity networks, amongst other things. However, I do believe the most valuable and transformative infrastructure projects that will happen from now and the next 20 years will look very different from what it looked like before. It would look like data centers. It would look like submarine cables that are landing from wherever in the world. It would look like satellite communications. We all have Starlink and we're enjoying it today. It will look like artificial intelligence platforms that we all use across different areas of our lives. Today we're using it for work. But what then happens when we begin to use it for medical checks, amongst other things? Then a fundamental aspect, digital identity. All of us have a BVN. So all of that intersects. If we were talking about payments 10 years ago, we'll be talking about creating the payment infrastructure. But the trajectory has shifted. We're talking about stable coins, amongst other things. So again, these are all issues that, if you look at it closely, intersects not only with every area of our lives, but in fact different aspects of the law. Today, the Ministry of Communications and Digital Economy has piloted a project named Project Bridge. Who has heard about it? So Project Bridge, for those who don't know about it, is a public-private broadband partnership to build 90,000 kilometers of fiber across the country to enable our acceleration towards the 4th industrial revolution. That one project alone touches corporate restructuring, project finance, infrastructure regulation. It is a live example of what I mean when I say technology law, in reality, has become infrastructure law. Another thing I would add that doesn't fit squarely in what we're discussing today in terms of Technology 101 is to realize that for Project Bridge, before any fiber is laid or lit, somebody needs to negotiate the right of way. Laying the fiber, putting a mast in someone's land, it is not internet communications on technology law. What type of law is that? Exactly. That is property law and land law. It is the oldest and most basic doctrine in our profession. Doing quiet work underneath all of that fancy technology work we talk about. I am speaking to practitioners, so we must connect all we're saying to how do we apply it to become the technology lawyers or the lawyers of the future. So for me, I know Fernandez in his speech, he made references to a couple of laws, right? And I challenge us to say, if you want to practice in this space or be a lawyer of the future, you need to understand even beyond data protection and telecommunications licensing. You need a lawyer in your firm to be able to advise on that project, someone who would be able to understand what does this survey mean? Are we able within this area to be able to So again, basically, the point I'm making is, for you to be the lawyer of the future, you cannot simply just focus on saying, I need to understand data protection or technology law. It is increasingly infrastructure law, and you must be able to understand the foundational aspects of what it means to even be a lawyer, because it is that foundational knowledge you will now transpose into the advisory work you will be doing, whether you're advising a fintech licensing company, whether you're advising an IP company, whether you're advising a crypto company, amongst other things. If then technology is infrastructure, what I always say is the national security has entered the conversation, which is a very uncomfortable position all of our clients don't like to hear. Before now, protecting our borders or national security meant you put policemen around. Today, the Cybercrime Act recognizes data, telecommunication networks, and computer systems as critical national infrastructure. The legal conception of what infrastructure means, even by that alone, you can see has significantly shifted from just being physical to digital. So imagine if NIBS went down, what will happen? We've all experienced it one way or the other. Imagine if, I should use this, okay. Imagine if there is a cyber attack. We've had experiences at some point. We're all lawyers in the room. You can imagine the crisis that arises in that process. And again, these are not hypothetical scenarios. They are real cases that we are dealing with today. That means the question and the challenge before us as lawyers, not only as technology lawyers, but even as general legal practitioners. When advising on a data transfer or cloud service agreement, where will the data reside? That's a critical question. Should government data be stored outside Nigeria or in Nigeria? What protections even exist for critical national infrastructure? You see, we had to create a framework for investors to feel comfortable of bringing in their own resources to ensure that when they come and invest and any crisis does happen, there is a clear legal framework that not only the laws that are available, but the state is also backing them, because it really touches on the survival of the nation one way or another. And we have also seen in the last few weeks signaling from the central bank saying data localization is no longer an option. In fact, it is something we must begin to do today. Can I have the next slide, please? So, Opealua says a regulatory landscape, not a silo. I think he would have hoped for me to sort of do an overview of all of the, but I think we're all lawyers and we understand. It's tempting to go over it, but I don't think that's the point of this conversation. The point of this conversation is to tell us that no single regulator owns the technology space. The NCC owns, of course, the licensing process. NIDA owns the data infrastructure. NIMC owns the identity management. NOTAP owns the technology transfer process. FCCPC owns consumer protection as well as competition, which still affects the work NCC is doing. The Office of the National Security Advisor looks at how does it affect our national security. I'm sure we all remember the Bitcoin, Binance incident. At the time when you look at it at the face of it, you'll be like, Nigeria doesn't know what it's doing. Nigeria is stifling innovation. But the reality is now national security has evolved from just being using arms. It is at this level. And the conversation starts with all of us here. It's happening in boardrooms and within agreement. Again, many people look at this and say, this is regulatory chaos. But for me, what I always say is, this is what happens when technology stops being one sector and it becomes an infrastructure that advances an economy, because it cuts across every silo that our regulatory architecture was originally built around. And if you look historically, technology leadership was never accidental. it's always very easy for us to reference other climes. You know, they will say in other climes this, in other climes that. So I'll give reference with at least somewhere I'm a bit familiar with. The United States did not become home to Anthropic, to SpaceX, and all of these other companies by accident. It benefited from an all-of-government approach. The executive, the legislature, and even the courts were all singing the same hymn. Go ahead and innovate, and we would be able to deal with it as it comes. A number of you here who are very familiar with the social media regulation would know about the Communications Decency Act. It is what liberalized YouTube to be able to continuously post music, that we can all post a video and say there is no copyright to it. It is also what gave platform immunity to a lot of the social media companies that we know today. The UK and the EU, of course, chose a more sort of prescriptive approach in line with its nature to say, okay, you know what, these are the transparency rules, these are the things you need to do. For me, I don't think either is bad or we need to pick one over the other, but I think the real question we need to ask is not how many regulators are intersecting across these areas. I think the question each of these people need to ask is, how can we find alignment while each of these regulatory agencies maintaining its own core? And for us here as lawyers, I think the answer is very, very simple, but it is quite demanding. The technology and communication lawyer of the future is not a specialist in one statute. That lawyer is a generalist who can move fluently across 6 or 7 regulatory lanes at once with commercial fluency within one single transaction, because the client will not experience those issues as separate silos. They will experience them as one deal, one platform, governed by all of the government at once. So if then that happens, what then happens to our own practice? Because you may be tempted to think, I need to go and read about all of these laws, but that's not the reality. How do you become a lawyer of tomorrow? Or how do you even build a law firm of tomorrow? And I would maybe ground it in telling our own story of how we became sort of established within this space. We take pride in being trusted counsels to clients who are challenging status quo. And it's not a marketing line, but it's a closer description to how we ended up practicing in this space at all. We did not even set out to build a technology law firm. In fact, the reality is we don't even describe ourselves as a technology law firm. We set out to build a law firm that understands in depth the intersection of business, technology, and regulation. A firm that could say it's possible when a client walked in with a problem, just like Fernandez's client came in, and no law has quite caught up with it yet. It is in that process we advised a drone company that was delivering health logistics at the time when the laws were there, but okay, so how does it really apply to the kind of work that we're doing? Or a renewable energy company that is saying, you know what, I want to share renewable power, but I want to use the existing networks, you know? So this is, again, at the end of the day, energy. Or maybe a data center that is relying on another energy company to supply them power. But the reality is we could not have advised that data center or if we did not understand even the fundamentals of energy. We do not understand the fundamentals of gas supply. We do not understand the fundamentals of the interconnection agreements that needed to happen for the gas to move from wherever the pipes are laid to the center, and even the landlord that they will go and build the data center there. Because fiber needs right of way, data center needs power. In both cases, they all intersect with technology, but underneath it all is a basic understanding of law, but applying it fluently across areas that are seemingly emerging. So for us, like I said, we didn't choose to be a technology law firm. I think my professor once told us when he was in school around 1999, people used to call people internet lawyers. I feel 10 or 20 years from today, nobody will be calling themselves a technology lawyer because it will literally become obsolete. So if you are in this room, what I ask, you do not wait for the regulations to exist. You become fluent enough in the law that already exists, including the law that has nothing to do with technology, on its face, to serve the client who will arrive before the regulation even comes to life. Because most of the clients we referenced here, the reality is a lot of the work we did for them, the rules for their operations did not even exist at the time. It is always very tempting when we have these conversations for everyone to say, but they don't teach us this in the law school. Yes, that is true. And it is unlikely to change very quickly, but it's not a matter for today's conversation. And it is not a call for curriculum reform at all. That is someone else's fight, not Fernandez's fight. But I believe the lawyers who will own the space in 10 years are not the one waiting for the syllabus to transform, or the ones that are waiting for certain shifts to happen. They are the ones that are building fluency by doing. They are the ones taking matters nobody else has seen it even as a wicked problem that needs to be addressed. For instance, we have several data protection lawyers. I always ask, is it really within the exclusive list? Or what if the states wake up and decide we want to go the other way? So for me, as lawyers, our role is not in waiting for the laws to be prescribed for us to apply it to the operations of our clients. It's for us to look at how are we operating within the existing laws and how can we expand it to ensure that there is not only room for increased innovation, but there is also alignment between innovation, national sovereignty, and protection for individual rights. So, for me, since today I don't need to go to a phone booth to call my mother, I believe some other lawyers did the hard work of making sure that the NCC Act was passed in 2003. The work in front of our profession now is to build the scaffolding for what comes next. And what comes next is not necessarily what we imagine already exists. If you're a fintech lawyer and you're still talking about payments or transfer, you are 10 years behind. The future is talking about stable coins. If you're a property lawyer and still thinking about, I need to do a deed, you need to start thinking of how do we transfer ownership using distributed ledger technologies? How do we transform registries from relying on paper-based approaches to property transactions to more distributed ledger type technologies? It is us, the lawyers, that will trigger this type of conversation. And then if you're more on the civil side, the next person that will come to you for trespass, I promise you, would not be anybody walking into anybody's house. The conversation would be, somebody is flying a drone over my house. That will be the type of conversations that we will be having. And the reality is, we should not wait for the laws to be tested in court before we start engaging on the issues and having this type of conversations. This is why I say forums like this are not only what challenges us as lawyers, but I believe forums like this are what will transform the legal profession in Nigeria to compete with anyone at any scale. Well, the history has gone by. The future is now. So do not wait for technology law to be assigned to you as a specialist. In fact, don't even call yourself a technology lawyer. Focus on being an excellent lawyer across the core areas that you are practicing and incorporate technology within that processes. The lawyers who did this early are not the ones who will only practice technology law. They were the ones who would actually remain in practice for the next 3.
All right. How many of us enjoyed that presentation? How many of us did not know about a phone booth? Be honest. Remember, we said we will not be the ones who will be afraid to ask the basic question. Excuse me. Not that one. Keep it back. Can you take this chair and bring it forward so she can face the audience? So, during this next segment, you in the audience will have an opportunity to ask questions and get answers to those questions. I would really be interested in seeing how this plays out because I know that there are some of us here who have been described as technology lawyers, who after today will now become just lawyers. And some of us also have something that we can contribute. So, do we have any questions in the room or online? There's no.
Thank you very much. But I'm assuming you are referring to if you're using like a platform that has experienced a data breach. So when it comes to the rules of evidence to present in court, it's not the technology law that defined it. The law of evidence is very clear. How do you present electronic evidence? And your pleadings and the rules of court have not changed just because the matter is a technology matter. Now moving straight into the particular platform you're trying to rely on, you're trying to claim a breach for. For you to claim a breach, of course, you are relying on the provisions of the Nigeria Data Protection Act, right? And then every platform is required to have a terms of service and a privacy policy. And it is clearly prescribed how to go about every step, how they are supposed to take steps to protect your data. The problem with enforcement when it comes to the NDPA is in terms of establishing even the chain of evidence. Because the reality is, as a lawyer, your case is dependent on your pleadings. The court can't give you what you did not ask for. So you may be the technology lawyer who understands the issues, who understands the rudiments. Perhaps you may want to speak to Abdul Ganiyu and say, Abdul Ganiyu, this is the law, these are the issues. How do we present this case in court? When I say a lawyer can be a generalist, but it doesn't mean you should know everything in total, because the law is a very collaborative profession. So again, my belief, my recommendation to you, look at the terms of service, look at the privacy policy, and we shall continue to test the courts. When I look at some of the pleadings which we go to court on, when you look at it, in reality, they are not even data protection issues. And there are gaps that, of course, there's a famous judgment we've all been analyzing within the space. When you look at some of we will say, the judgment of court, but again, my lords in their wisdom had the reason to give that judgment because it's based on what we present to them as the evidence at the end of the day, which is why the premise of your question was important. How do you collect, gather, and transmit that evidence? Go back to your terms of service. If you don't have it, take them to court to give you the information, and they can't tamper with it, because once you tamper with it, it will be clear.
That was a very interesting question, and I was so curious to see how she would handle it, and I think she did an excellent job. Do we have any other question? Yes, there's a lady at the back.
Good afternoon, ma. Thank you for this session. It was enlightening. Actually, I have written a couple of papers on technology law. And what do you think about the fact that there is no specific regulation, considering that it is an infrastructure now? And I agree with you on that. What do you think about the fact that there is no specific regulation on it? You know, NCC is saying one thing, NITA is saying something else. We have the NDPA too. And now it's all over the place. Then, you know, even startups, the companies already existing and all, they have a problem as to where are we floating to. And even for practitioners in that field, there's also a challenge of what do we do when, and okay, recently now, NCC came up with something else in line with all companies that, where there's a change of director or a change in the company structure, the NCC has to give an approval or something or such. So it's quite concerning that despite the fact that technology is fast growing, I feel like the Nigerian regulatory system is drawing us back to an extent. I just feel that way. But what do you think, ma'am? Considering that there is no regulation, there is no exact regulation on technology law. Thank you.
I didn't get your name.
My name is Kehinde Naima.
Kehinde. Kehinde. Thank you so much. And hi to your baby. Thank you so much for coming and with her as well. I think it's the point I was making earlier. The regulation is not a silo. No one regulator owns one space. But you have to look at each issue case by case. I would answer specifically to the reference you made in terms of a change of investor. The NCC just came up with a law, with a regulation. But then a regulation comes up by virtue of an act, right? It's an offshoot of an act. So did we go back to the act and check? Because the reality is, from my last reading, I've not done any licensing work at the NCC of recent, but to my knowledge, before a license is approved, you would submit who the shareholders are, the sources of their funding, because remember, communications infrastructure, anything licensing and communications is now critical national infrastructure. So on that basis, there must be a certain level of check and understanding. Who are these investors? Where are they getting their funds to invest and obtain this license? We've granted you the license. It is you that we checked. We've not checked the person buying your company or where the funds that they're using to buy the company will come from. But if you do, as a lawyer, feel it is an overreach or it is stifling innovation, please feel free to challenge it. I made reference to the Communications Decency Act and Section 230, particularly because when they took it to court, the entire law, every provision was struck down, but except that one section, to give platform immunity to YouTube, because somebody was, and the reality is, the reason it even went to court wasn't even for technology or anything related. It was for intellectual property, that somebody posted a video of his baby on YouTube playing the music that they didn't get the copyright for. So if you look at things holistically, it is our responsibility to now pick the laws that apply to each particular case. God forbid the lawyer who knows all the law, but at least we should know where to find the right one.
Do we have any other questions? One more. All right.
Good afternoon, everybody. Sorry for my voice. I was hate watching. So, okay, so it's an offshoot from your response. Don't you think that in itself is the problem? Particularly as to the fact that with each passing day, technology is advancing. There are issues of deepfakes, issues of people trying to present people as doing things they didn't do. In situations like this, having to go towards too many legislations to get your clients, to get justice for your client, don't you think that in itself is a problem? Don't you think we should have a holistic, a point focus, something we can look at to resolve problems like this? For example, Meta and Femi Falana's case, he has to go through the constitution, go through quite a lot of things. And at the end, it did not hit the focus of his issue. That's my problem. His problem was the fact that he was, on Facebook, there was a video circulating where he claimed to have some health challenges. Yeah, prostate to be specific. And he was used to advertise product, which he didn't do. In situations like that, do you come under breach of privacy? Do you come under personal liberty? Do you come under the commercial law? Particularly the fact that that company had made money and is entitled to a fair share of that portion of money they made. So that's the problem. How do you, with the fact that too many laws are scattered, how do you harness everything to the best interest of the client?
Very interesting. I attempted as much as possible not to talk about this case. But I guess it's a wicked problem in our jurisprudence today. And wicked problems are always very useful because it challenges our thinking as lawyers. So to my mind, and this is my opinion, please, and it's not an analysis of the judgment. Relying on what you said, somebody relied on his picture, used his image and likeness to advertise and make money for it. That somebody was not Facebook. Somebody posted on the Facebook account to use his image and likeness to make money from it. Of course, to my mind, it's not a data protection. It's not data protection as a first layer. But maybe his lawyers, in their best knowledge, decided to go through data protection. And then on the second layer, Facebook, of course, is a necessary party to the suit because they had information he needed to be able to pursue his case adequately, which comes back to the question he was asking. What I would see in these issues are two different things. One, I have a tortious liability that somebody has used my image and likeness. On the second part is I need information from Facebook, or I need to hold Facebook accountable to be able to. But then for us, if the UK have the Digital Services Act, what do we have that regulates the platforms, that ensures that there is a certain level of transparency, there's a certain level of accountability, there's a certain level of protection that they're required to provide to us? You may not recall, but maybe around 2019, at some point we shut down Twitter in this country. But again, they said the reason why they did that is because the President of the Federal Republic of Nigeria, may his soul rest in peace, his account was used to post something that was not in line with their terms of service. And then the state now said, no, you didn't notify us to take it down. It is within your terms of service. You didn't follow the steps within your terms of service to do what you needed to do. But again, it now became a situation of, and this is what they said, this is what he said. But we must also be comfortable challenging the system and also challenging the platforms. Because the platforms gives me access. It doesn't give you a right to make me a victim of your own rules. Many people have businesses, and you will see on Instagram, it says, my page has been taken down. What was the basis for that? We have people that go through fraud online, and these are legitimized businesses online. So as a nation and as a country, if we have not defined how we want to regulate platforms, as lawyers, we now have a responsibility to define the issues for the court, for an outcome to be provided to us. It is at that instance you would find the legislature, the judiciary, and the executive singing the same hymn. But it can't be that I would not hope we will have one law saying that this law, it is what regulates technology, because technology is infinite. Innovation is always ahead of the technology. If we are waiting for the law to happen before the innovation will happen, I don't think we'll be doing a lot of the things we're doing today.
Thank you. We have a question over there.
Yeah. Good afternoon, everybody. I want to simulate my Oga by looking at my watch before I greet everybody. Thank you very much, Ms. Hamo. It's always a pleasure to listen to you. Mine isn't particularly fully a question. I wanted to just draw from the narrative presented because it aligns with the basis upon which you gave us that today's lawyers should not call themselves technology lawyers. I often give that advice myself. And the reason is very simple. one example you mentioned about the drone, we can take it as far back as the maxim cujus est solum, ujus est oscud, ad coelum et ad inferos. Whoever owns the land owns it to the depth of the earth and as far as the sky goes. Now, that maxim seems to have been gone when we moved to solo said it. But there's no law wiping it off. So we can always go back to it, reignite it, and reuse it. You will not naturally learn that in a technology law class because there's no technology law class. But you've been given the tool right from probably when you were studying your land law class that whenever technology comes, you can re-navigate the issues around these laws. To the Falana scenario, I read the judgment myself, and I understood that the dimension of that case was whether or not Facebook even ought to be liable in that judgment, because Falana went to court on breach of privacy, Section 37 of the Constitution. And then I asked myself when I read the judgment, at what point did Facebook breach the privacy? Because the issue on ground was an AI-created advertisement made by Falana. Typical deepfake where someone is lip moving and then saying something's voice over it, that yes, I had prostate for certain years and I used this drug. If you use it, it's good for you and all of that. Now, it was advertised on Facebook, yes, but there was no takedown. There was no takedown notice given to Facebook. So I myself didn't see where Meta became liable. But one way or the other, issue of, and it was by originating summons, so there was no witnesses called. It was a one-way traffic affidavit evidence, and that went that way. But the dimension around all of this is that sometimes it's not fully a case of technology law. It's just a case of other areas of law streaming from the use of technology. And that's where I want to just add that credence to the narrative you use by all the infrastructural issues coming together, and then us drawing the concept of, because as a practicing lawyer who just wants to do compliance, perhaps the divergence, the convergence is where you want to function as a lawyer to assist companies to carry out compliance issues, filed for their license and all of that. You limit it there. Then you have the very wonderful question from my brother here about breach. You're seeing streaming into litigation automatically, where you're having a case, an issue of technology is creating a litigation issue for you. So you're not going all out to say, I want to just study technology law and leave it there. You're then probably defining yourself at what area of law do I want to practice in, and then I can harness all of the issues around it to present my case in whatever circumstance I find myself. That's just what I want to put in contribution. Thank you.
Thank you so much. That was so well put. We'll take one more question from here. This will be the last question for this session. If you have any other questions, please, I encourage you to write it down. If we get trapped in this place because of the rain, and we anticipated that yesterday, you're in luck, because that means you have all the speakers and everybody here to contribute to your questions. So please take note of it. Sir, over to you.
My name is Kamarudin Ogundele. I'm Senior Special Assistant to the President of Communication in the Office of the Attorney General of the Federation. I want to narrate a scenario. A woman was arrested in Oyo State because they traced some accounts to her name. And those account numbers were used to perpetrate fraud. So she was arrested. From Oyo, she was taken to Lagos. From Lagos, she was brought to Abuja. In Abuja, after the police investigated the matter, they discovered that her data, BVN and NIN, were fraudulently used by unknown persons to open like 16 different accounts, which they used to defraud so many VIPs. So at the end of the day, she was freed. But how she went back to her destination, the police, they were not involved. She was left on her own. So a relative had to go and secure her release before she went back to Ibadan. Now the question is, this is a case of data theft wrongly used by persons in connivance with some bank staff. Because if you want to open an account, I'm sure it is a recommendation that you must have a physical contact. So what are the options available to this victim?
So maybe Abdul Ghani, this is a pure criminal law case. That's the reality. So the good thing is her innocence was been able to be established. And now going back to the premise on the fraud around the BVN that was used, which is within the banking system, as well as her NIN that was used, which now sits with NIMSI. It's exciting to know that today we're having these conversations on the protection of our own identity. That's why I said identity is now a critical national infrastructure. We have a new NIMSI Act that has expanded the scope of the issues NIMSI can address and litigate when it comes to issues like this, and rights for us and as individuals. Before you change one letter in your name, it took a whole new process. But the journey has been going on in the last 2 years. I can't remember what they called it. They launched it last year on the National Identity Day that allows us to own our data. Even if there is tampering with it, you would be able to be aware. So the problem is the legal foundation may exist, but are we even aware it exists? And if we become aware it exists, how do we frame it to the current issue that we are dealing with? I'm not holding brief for her. If I can establish a breach against the state, I will sue the state, because I trusted you with my information. So we need to begin to test and challenge the law on real case scenarios that affect everyday lives that will advance us, as opposed to just pushing forward cases that we're just hoping to get a nice cash day out. Because they say data is money. But the reality is not that data is money. Data is our identity is beginning to define who we are and what we do. Because if I'm hiring somebody in the next 10 years, I don't need to do criminal investigation. The NIN is good enough to be able to give you that information. So a lot of these things is also not an event, is a process. And the reason why, again, I say it cannot be one regulator. It must be an all-of-government approach. Because you see, today, NIMSI is not even under the Ministry of Digital Communications. It's under the Ministry of Interior. This shows you how it's actually internal security issues. When it comes to data centers, it's not with the NCC. It's with NITDA. When I'm bringing in technology to operate a hotel, who would imagine I would need to go to NOTAP to register the hotel operating system? So again, as lawyers, we must be able to define the length and breadth we want to expand, because the law can be stretched to anyhow you want to stretch it. If you limit it, it will be what will stifle your innovation. We take pride in identifying how we'll use the existing laws to ensure that that thing that you want to do is possible.
Thank you so much, Ms. Saadatu Hamu Aliyu. I think we can do better than what we just did, because it did not qualify as a round of applause. And I remember when she first came on stage, she said something about 10 claps. Yes. So, how many claps have we agreed to give her? All right. 12? Okay. Are we going with 12? All right, let's go with 12. Thank you very much. Thank you. So before we continue, I'd like to recognize the presence of certain dignitaries that are in our presence. We have Marcus-Obiene, who is the Executive Secretary for the Administration of Criminal Justice. We also have that's the Executive Secretary, Administration of Criminal Justice Monitoring Committee. Please, a round of applause for her. We have Oloyede Hussein, who's the Senior Special Assistant to the President on Arbitration and Drafting. A round of applause for him. Can we also put our hands together for Olayombo Ade Ojo, who is the Senior Special Assistant to the Minister of Industry, Trade and Investments. Okay, usually when we want to recognize someone, we'll see like a wave of hand or a thank you so much, thank you. We also have Kamaruddin Ogundele, who's he's the one who just asked the last question. And before we continue with our agenda, the Senior Special Assistant to the President on Media. Another round of applause, please. And thank you so much for the engagement. I've been made aware of the fact that we're having technical difficulties, which is ironic. This is Technology 101. But sometimes we see these things happen. And so we would like to offer a profound apology to the 2 judges from Kaduna State who are experiencing serious difficulty with joining online. On that note, we would also like to apologize to all the participants participating online. We are so sorry about the technical difficulties that we're experiencing. If you're online, you can also stream live on Instagram. I think Law Corridor is streaming live as well. Please, another round of applause for our very generous sponsors. Moving on to the next item on the agenda, I'd like to invite on stage the next speaker. She's going to give us a workshop, an industry workshop, and the title of her presentation is Behind Every Ring, the Story of Interconnection. Before I introduce her, please allow me to quickly read her bio. Our next speaker is Antonia Oluwateniola Ogudipe Ayondele. She's the Manager, Special Projects and Next Gen Regulation at MTN Nigeria Communications PLC. Antonia is a telecommunications and technology policy professional with over 14 years of experience in regulatory affairs, public policy, legal advisory, and stakeholder engagement. She's experienced in developing regulatory strategies, navigating complex policy environments, and fostering collaboration between government regulators and industry. Her work spans telecommunications infrastructure regulation, digital governance, data protection, spectrum management, connectivity, and emerging technologies. She's passionate about making complex technology and regulatory issues accessible to diverse audiences, as well as supporting the growth of resilient, secure, and sustainable digital ecosystems. Ladies and gentlemen, please put your hands together for our next speaker, Antonia Oluwateniola Ogudipe Ayondele. I think we can do better than this. Thank you.
Good afternoon, everyone. Okay. Can I please have the slides up? Thank you. The slides seem to be a bit cut off. It's fine. Okay. All right then. So, most of us, I mean, pretty much all of us here make several phone calls in a day. And I'm not sure if any of us has ever stopped to ask what happens when you dial a number. And I guess today, I just want to run you through what happens in terms of the journey of a phone conversation or a phone call. And I'll be using that to explain a very foundational concept in telecommunications called interconnection. Next slide, please. Okay, yes, it's complete. All right, so we'll look at the definition of interconnection. Basically, what is interconnection? We'll follow the path of what a phone call basically goes through to be able to connect to the other party. We'll identify some of the ecosystem players and examine the legal framework around interconnection. And we'll also look at what a typical interconnection agreement entails. Some of the additional things we'll look at will be some of the challenges we're having in this space. Recommendations have been made by operators within this space. And lastly, just a few key facts that we just need to remember to take home with us. Next slide. Okay, so I want to play this. I'm not sure if this can play. Can you please click on the... It's not possible. Because I embedded a video. It's a very short video. Do you... yeah, but it serves as the foundation to the next conversation, actually. You can copy the link out and then play it on YouTube directly. Ah, I see. So I think it's just a security issue as well. Apologies for that. I mean, so pretty much the video just sort of shows the journey of a phone call when it's initiated, as it goes from the phone transmits it to the tower. So please excuse me, just a minute. Apologies for the delay. They'll play that video shortly. And while that is ongoing,
God of Exoverse, DJ Wizkill.
some soothing music to relax us. Okay. Maybe I'll just move on to the next slide, and then we'll kind of come back. Yes. So basically, what that video was going to show us was what happens when you make a call. This particular diagram at the top of this slide shows pretty much the same thing. So you initiate, I'm not sure if you can see this side, but yes, there's a phone here, and then there's the mast here, and I think you can see the rest of it. Okay. All right. So when you initiate a phone call, right, the antenna of your phone will take whatever you're saying and then turn that into what I'll call binary code, more or less, and then it transmits it to the antenna of the nearest base station to you. That's because the antenna of your phone is too small to be able to do that transmission, so it needs to be amplified. And that goes in as sound waves to what we call the mobile switching center. This mobile switching center is what we call the core network in a telecommunications company. And it is here that, to a large extent, interconnection happens. Now, when the switching center identifies what sort of information is coming into it, and then it routes it to the switching center of the other operator. And then that one takes that information, converts it back into waves, sends it to the nearest base station closest to your recipient. And then that the station transmits it back to the person's phone. Or more like to the recipient's phone. In this instance, this happens literally in milliseconds. You don't even notice it. It's sort of the period you wait for the phone call to start, right? And that's sort of what the video was supposed to just run through for us to help us understand it. Now, when we talk about interconnection, we're talking about the connection between two different networks. So imagine if you have an Airtel line and you're not allowed to call any other network. You're stuck with Airtel. You can only call within your network. What would happen? You won't be able to have essential communications, essential services you're trying to reach if on a different network will not be possible. Businesses you're trying to transact will not be possible. And that's where interconnection comes in. And it is this exchange that happens at the switching center that we basically call interconnection. There's the physical part of it or the logical part of it, and then there's also the legal agreements that govern it and the legal frameworks that also govern it. Is the video able to play now? They're about to play it. Okay, so I'll just stop here so we can watch the video very quickly, and then we'll continue. while we wait for that, the point where those two networks are interconnected is called a point of interconnection, or a POI. And it's basically the agreed physical or logical location that the two operators have decided to connect their networks to in order to be able to exchange telecommunications traffic. Just think of it like what we call a junction. You have two separate roads and they meet at a particular point. That's what we call a point of interconnection, pretty much. Okay, should I move on to the next slide? Yeah, so please move on to the next slide because I'm done with this side. I mean, these are the technical definitions of it from the ITU, which is the UN agency in charge of telecommunications. We also have the definition by the NCC and by the GSM Association. But I'd already described it in very simple terms what interconnection basically means. Now, why do we care about interconnection? Interconnection basically, as we have explained, allows customers on different networks to be able to communicate seamlessly. It also allows you in that same breath to be able to expand your service coverage beyond just what you ordinarily can access on your own network. It also provides a level playing field because it's heavily regulated. Since it's so core to the telecommunications network infrastructure, it's heavily regulated by the NCC, who's the telecoms regulator. And so it allows all parties that have a right of interconnection to have a level playing field. It also allows for efficient resource utilization because that way you don't have to be duplicating your efforts by going to build infrastructure every single place. You just interconnect with the other party and then everyone has access. There's also, in terms of revenue enablement, it allows you to exchange traffic. When that happens, then you have to settle your bills. Whoever is in a payable position, which means that when you send traffic to me and I send traffic to you, we net off. So whoever is left in a payable position where you are the one owing more money than the other will then settle. So there's a whole process around this. And one thing I also wanted to point out here is that it provides what we call resilience and redundancy. I would explain. No, please don't. Go back to the next slide, please. Go back to the previous slide. Thank you. It provides for resilience and redundancy. So you would see in this slide that there are two scenarios where you have a direct interconnection. So this is where basically you're just making a call from your own network to someone else on your network. There's no interconnection here. But when you're making a call from your own network to another network, then there is interconnection and it is direct. There is also a scenario where there's indirect interconnection, where, for instance, in this particular instance here, you have an MTN line making a call, trying to reach maybe Airtel, but it passes through a middle party. Now, in this place, this particular entity is what we call the clearinghouse, and I will explain that in the next slide. And so the party that it's passing this traffic to then determines from its own switching center where the traffic is headed. Is it heading to Airtel? Is it heading to T2? Is it heading to Glo? And then it routes it in the appropriate direction. So we can move on to the next slide. Oh. Okay. All right, we can go back to the video very quickly and then we'll come back to the ecosystem.
When you talk on a phone, it feels instant, almost like your voice just flies through the air. But what actually happens is far more complex. When you talk on a phone, it feels instant, almost like your voice just flies through the air. But what actually happens is far more complex and hidden from view. Your phone captures your voice and turns it into digital data almost instantly. That data is split into packets and sent out through radio waves to a nearby cell tower. From there, your voice travels across a maze of routers, servers, and switching stations. It can pass through underground fiber cables or even bounce off satellites. Every part of the journey is timed to the millisecond to avoid delays. Only when those packets reach the other phone are they turned back into sound. So what feels like a simple voice call is actually a high-speed digital relay. Your voice takes a longer journey than you think, and it does it in real time. For mind-blowing tech, follow the tech teller. When you talk on a...
Thank you. So that was basically just an explanation of the same thing I had earlier stated. So now we're on to the ecosystem. To the ecosystem, please. Thank you. Okay, you can't see this side, but this side has what I'll call the mobile network operators, the MNOs, which MTN happens to be one of them. Now, their job, thank you, their job is basically to originate. So that's where the call starts from, and then they terminate the call when it comes to their own network. Of course, you know the main four, and then there's Smile Communications here as well. Then you have the clearinghouses. They, like I said, are middlemen. They were created at a later stage after the MNOs were created, when it was realized that not every smaller operator had enough traffic to justify having an independent point of interconnection. So in order not to waste resources, they created a license for middlemen, clearinghouses in this instance. Interconnect clearinghouse is just an example of them, for you to be able to aggregate all of that traffic. So they aggregate the traffic, they get it from different sources, they aggregate it, and then they route it in the different directions it's supposed to go to. That allows basically efficient use of resources, of very expensive resources. So instead of, let's say you come and you're saying, I want like a 50 GB of capacity, and I'm just using this in colloquial terms, and then another person comes and says, I want 20 GB. The interconnect clearinghouse will come together and aggregate all of that. Maybe that point of interconnection can carry 1 terabyte. So it aggregates all of that traffic together and then sends it in the direction it's supposed to go to. And that allows for a smoother ecosystem. It also does settling. So it's an exchange, right? It basically will now be the one to go back and tell you, you sent 40,000 minutes today, and you received 50,000 minutes today. And then it does sort of the setup for you to know what exactly you're owing in terms of the value of the traffic that you sent. We also have other ecosystem players. We have the IDAs, the International Data Access Licensees, whose job basically is to carry international traffic. They carry it out and they also bring it in. You have the PNLs, which are more or less like point-to-point network providers. They are local players. They tend to operate in smaller regions. I'm not sure if people remember companies like Oduatel, VGC Communications. So those were PNLs. Yes, not everyone here would remember those, but those were at the very beginning of this new telecoms era that we have. And they had smaller localities that they basically covered. So Oduatel, if I recall, was a regional player in the Southwest. Then you have the MVNOs, who are the latest entrants, the mobile virtual network operators. They also have a right of interconnection. And so the way they operate is that they have a host network. They're on a host network. But aside from the network that they're being hosted on, they have a right to interconnect with every other network. And what basically just forms this ecosystem and puts it together is from the commercial aspects, which is usually covered by the agreement. There's the actual physical interconnection done by the engineers. And there's the regulatory notification. When you're done with all of that, you are required to submit the agreement to the NCC for review to ensure that it complies with all of their rules and the consumers are protected. Next slide, please. This is pretty much the regulatory framework that governs interconnection. You already know the Nigerian Communications Act, and then you have the interconnection regulations itself. You also have the guidelines for disconnection, and there are some other guidelines that are relevant to it, including your license conditions, and also the competition regulations are also relevant to interconnection generally. But I will not dwell here. We'll move on quickly to the agreements because we've spent a bit of time. This is just highlighting the key sections you need to know. Like I said, interconnection is mandatory. You don't have a choice. However, you could have a reason for delaying it. Maybe you don't have capacity and you need to build up your capacity. And in that instance, the Act and also the regulations that come under it provide for an opportunity to explain to the NCC why you have to delay that interconnection. However, it is mandatory. At some point, you do need to ensure that interconnection is granted to whoever is requesting it. As stated previously, the framework that covers it is the agreement. And you cannot disconnect an interconnected operator by your own self, of your volition, even if your agreement allows for it. It is required that you obtain regulatory approval. Why? Because it's carrying live traffic. there are subscribers that rely on that interconnection to be able to make calls for all sorts of purposes. And so you do require approval from the regulator to be able to terminate or suspend an interconnection relationship. And that ensures that competition levels are maintained in the industry and also protects the consumers themselves. So now the agreement really is, like I said, the rule book that governs that relationship between the operators. It generally will cover things like technical and operational clauses, defining the scope of that interconnection, clearly stating where you plan to have the interconnection, the point of interconnection situated. It also addresses things like capacity planning and forecasting. And then you have commercial clauses that also are relevant to billing and accounting for the traffic. I'm going to move on very quickly. It also has aspects that relate to risk management, where it defines who's responsible for what the liabilities are. It also covers things like network security and proactively provides for dispute resolution clauses. Under the NCA, you do have a right of recourse to the regulator if you're having issues between both parties. And it also tells you, to a large extent, what would happen if you have to suspend services or interconnection is terminated. So these are basically the rights. As explained earlier, you have a right to request for interconnection. You have a right to receive it at a technically feasible point. You have a right to apply for dispute resolution if you're having negotiation issues, or even when it's operational, you're having issues with both parties. You also have a right to seek disconnection approval from the NCC, where you have the different grounds, but one major ground that tends to come up a lot is unpaid debt. You are required to negotiate in good faith. And in some instances, if you're found to be a dominant operator in that space, you are required to publish and maintain what we call a reference interconnection offer, which just means that you have a standard template for your agreement, pretty much, approved by the NCC, and you don't vary it based on who's coming to you for interconnection. You also are required to pay your interconnection charges promptly, and it's treated as what we call a first line charge on your revenue. So you pay it before you do anything else with that money you've gotten. And you are required to meet quality of service KPIs. Please go on. Now, the challenges that have happened or that we've seen in the industry, like I said previously, the most prevalent of them is indebtedness. It's possible if you might have seen in the papers instances when operators have sort of taken themselves to the regulator, and there were times when the regulator actually went ahead to publish a notice of disconnection. I don't know if anyone has seen those, but it's usually that's sort of like the final leg or final stage in a very long process. Typically, if you're having issues with your partner, you would have written to them several times demanding for your money. If they are not paying, you will then initiate what we call the disconnection process under disconnection guidelines. And that would require you taking out a particular form, filling it, submitting to the NCC. The NCC would have about 3 days to look at that and then send that form to the other party, asking them for a right of response, because they do have a right to respond. And then when they respond, they review that again, and then they send it back to you, the initiator, because you have a right of further reply. And after that, they then call for like a mediation meeting. There are usually resolutions reached at that meeting, and you're given a timeline within which those resolutions must be adhered to. If you're still not able to resolve those issues within those timelines, then the NCC will proceed to issue what it calls a notice of disconnection, and it publishes it, I think, in about 2 or 3 national dailies. It's seen as a very, it's seen as a stain, so to speak, in the industry if you actually get to that point, because there's such a long process for you to get to that point. So when you get to that point, you know that what has passed Gary. So we've had quite a number of incidents like that, and we have some operators that have residual dislike for us because we had to drag them through that process just to be able to get our money. And these are in billions of naira. So as we had explained, we have this interconnect indebtedness, and the process is long. And even when you don't get your money through that process, you can go to court. You have a right to go to court. But we all know how the process is when it comes to litigation. It can be so lengthy. And many times when we're done with that process, we find out that they don't even have money in their accounts because they've cleared out all the money. So even when you get the garnishee order and you want to have it executed, there's no money. The banks just tell you that, well, the money's gone. So you don't really get anything at the end of the day. So this is one area that we've been trying to have the commission address to make it faster. Another thing, and these two are related, you might have experienced times when someone called you from outside the country, but you saw a local number. This is where we call masking and traffic profiling, and also SIM boxing. There are different methods by which it's done. Depending on the method, that's what will determine the name. But call masking tends to be, will I say, the most common, where it basically, there's an international call coming in, and then the operator takes it and masks the number. So it takes out the plus, whatever the initial digits are, and makes it appear like a local number. So that when it comes into the network system recognizes it as a local call and charges it at a local rate, which is way lower than international rates. However, the person bringing in that call or that traffic has already collected the money at the international rate. So they only pay a lower amount to the operator that's terminating the call, and they get to keep all the rest of the money. So we've had so many issues when it comes to specific licenses. We've noticed that there are some licenses that are being obtained by individuals and organizations and combining them together. So one of them is that PNL I earlier explained is a local or regional operator, because you get a number range assigned to you. But then they combine it with an international data access license, which allows you to bring in international traffic. So they basically are allowed to bring international traffic. They have a local number range, so they just mask it into their local number range, and then they come and terminate on our own network. But nowadays, I mean, there's technology to be able to determine where the call line identification is originating from originally. And that's how we're able to go back in our systems to know that these calls are actually international calls being masked. But these two are quite connected, pretty much. And it's a major issue. It's kind of going down a bit because technology is a lot more sophisticated now. But even at that, we still have to drag ourselves to the NCC to get our money, if we're able to recover anything at all. So we lose quite a lot in this particular instance. We also, like I explained, the inefficient disconnection framework, it's just not working well the way it needs to work. And then now, because of changing technology, you're beginning to have a more complex process in terms of interconnection. We've moved from traditional TDM to things like you're now passing traffic using IP-based infrastructure. And not everybody's infrastructure is up to snuff. And not everybody's team is as experienced when it comes to interconnection. So sometimes that causes a lot of delays and a lot of complexity when it comes to this particular framework. Next slide, please. So as we had explained pretty much, some things have been addressed, but we haven't really been tested in court, such as the criminalization of the masking and refiling and bypass activities under the Cybercrimes Act. There's like a generic provision there that we try to fit it under. It's not specific. That's an area that we really want addressed. Economic issues where, or more like commercial, where you are allowed to build into your agreement that you will not interconnect with this person unless they provide you sort of like maybe a letter of credit or a bank guarantee for an amount maybe equal to 3 months worth of traffic, forecasted traffic. So that way, even if they owe you, all you have to do is to draw down on the bank guarantee. You also have licensing, because we've actually asked that specific licenses should just either be stopped or there has to be a more stringent due diligence process. And of course, the the corporate governance guidelines now, ensuring that allowing you to be able to lift the veil so that you can go after the individuals themselves, even right at the NCC disconnection stage. And so yes, disconnection as well. So please, let's move on very quickly. I think we're on to the last slide. Okay, so this is very technical, and I appreciate the fact that it is technical, and I'm just trying to hopefully break it down, because this literally is the foundation of your national communications network, the way it's interconnected. The first part that I want you to remember is that every phone call is both a technical process and a range of relationships, legal relationships, actually. And you also understand now that interconnection does allow for a level playing field, stimulating competition within the industry. And 3, the reason why you never really thought about interconnection is because you don't notice it until it fails. until you try to call a number and you can't get through and you don't know what's going on. Is the point of interconnected congested? Is there a need for them to get additional capacity? Those are some of the issues when it comes to interconnection. And then telecommunications law is as much about cooperation between competitors as it is about regulation, because we can't survive on our own. So there's really no value to trying to, according to some of the reports you hear, trying to kill off a competitor, because you do need your competitors to survive. And as the digital economy grows, interconnection will become even more and more critical, because it's the base infrastructure upon which the telecommunications industry relies. And I believe that's all. Yes. Thank you.
So let's have the usher bring the chair forward so that we can have a quick question and answer series. Would you like to stay here? Okay, she wants to stay here. So, questions, comments? Yes, sir. Can we have the roaming mic? Another one over here.
Okay, having introduced myself earlier, I will go straight to the question, or maybe a sort of suggestion as well. The story I narrated earlier, now, I know there's a code which you tap into your phone and send it to a particular through SMS that will reveal your BVN and your name. I don't know what is. I don't know if MTN could think of something like, if you want to make a transfer from your phone, the bank will request for your PIN. Then, if maybe you left your phone unattended to, and someone picks up your phone, by sending that code to your phone, the person can access your BVN and name. I don't know. Is it a way that MTN could protect? Maybe that will request for a PIN as well before your BVN or your name could be revealed to you. I don't know if you got the question. Okay.
From what you're stating,
data protection.
There's a code. Just let me go back to the very beginning. Okay. Thank you. So there's a code that if you were to impute it into your phone,
yes,
and send it to your network service provider, it will reveal your BVN and your NIN.
Yeah. Not service provider. I think there's.
Are you sending it to NIMC?
How do you get it?
Or are you sending?
I think
USSD.
So USSD.
So it's just the USSD, yes, and then you type it.
Yes.
Okay, I'm not aware of this USSD.
There's a code.
And your BVN and your name.
Yes. There are two different codes. Two different codes.
No, so what you're saying is that, so the short codes are assigned. If that's the case, I think I understand what you're saying now.
Yes.
But those short codes are the ones that are already assigned, for instance, in the instance of NIN to NIMC, which means that what you're doing by initiating that short code is that you're querying the NIMC database. You're not querying our database, because even we do not have your name. Whenever you come to a telecoms operator, we require you to use your fingerprints, and then the biometric identification is used, and we send it to the NIMC database to query it to bring out your name. We don't keep your name. It's not in our possession.
I know. What I'm saying is that if somebody is doing that through an MTN line,
yes,
is there a way you can ensure data protection that you are sure that it is the owner of the line that is requesting for that information?
So just to be certain, isn't that the number that is going to be linked to your NIN already? That phone number cannot be just a regular or random phone number.
I understand.
So what you're saying is extra protection levels.
Yes.
So I'm aware of APIs. Those are like application programming interfaces. They're like connectors. Let me put it that way. They're like. So I think I want to address this part, because some banks already use these APIs. And I think I'm just going to explain how it works to see whether it would work in this kind of instance.
Okay.
Now, APIs are the software I'll call them messenger software. They go on errands. And in this particular instance, for instance, there are some banks where, I know some foreign banks do it, and I think even banks here in Nigeria, if you were to try and, say, log into your account or you want to change a major information, it would query, if it has a relationship with your network service provider, it would send like a query at the back end to your network service provider to confirm if the location of the device is around the same part where you are supposed to be. Yes, I know Nigerian banks do that, actually. So the idea of that API, so that query is carried back and forth by an API. That's what we call the application programming interface. It's just an interface, right? And it sort of tries to geolocate where you are in terms of your device, that it believes that you're with your device and that your device should be maybe in the area where you have claimed is your residence. There are different ways it can be programmed. And then that way, it would allow that transaction to go through if the service provider comes back with like a yes. It's usually like a binary code, like 0, 1. 0 being nope, 1 being yes. So it comes back and it just tell you the person is not there, 0. And your transaction will not go through. But you won't know why the transaction is not going through. That all of this happens, once again, milliseconds at the back end. So there are levels to this protection, and typically those protection levels are available to entities including NIMC and the banking entities if they want to actually consume the APIs. The question is whether those organizations are willing to take on the financial, because there's always a cost to it, right? The financial burden to make it more, to make their ecosystem stronger in terms of protecting your data. Because if that shortcode is already designated to allow for such information to be brought, there's very little that the service provider can do. Even the shortcode itself is actually issued by the NCC, not to us. It is issued to the entity, so in this case, let's say to NIMC, and then NIMC will bring the letter saying that I have been issued this shortcode for this specific purpose by your regulator. So go ahead and program it. So there's, to a large extent, we have to do that. If you come to meet us for that purpose, we will do that because we've gotten that letter. It's basically like an instruction. So there's a limit to what we can do outside our own ecosystem if the other party on the other side is not willing to work with us. But it is possible.
Thank you. Because I also raised it as a question so that MTN and other telecommunications will think in that line. Because if I'm using my MTN line, I will be charged $20 or so. So where is the money going to? Is it MTN or NIMC?
No, neither.
Huh? Neither.
So there's a fee share between NIMC, there's a licensing, there are identification, there's a licensing process that is undertaken at, there's a licensing process undertaken at NIMC. There are a couple of companies registered for this identity verification. So for every time you put in your BVN, it is not just the bank that gets your BVN. It's that entity that is licensed that the query she's referring to queries the NIMC database, and then they now pull it out. And that fee, there's a fee sharing arrangement, and what they get is maybe like it's in kobos, because when you think of the amount of infrastructure you would have to invest to be able to do that data aggregation and transmission is quite significant. Yeah. So there are a couple of companies licensed by NIMC. Yes, I'm sure you've heard of Smile Identity so that's really principally what. So every time you put any application that asks you for your BVN, it's not that application that knows or has access to your BVN. They're relying on another layer to do your identity verification. The access that the telecoms provide, they provide that specific short code to NIMC to be able to give that based on the phone number that you have registered your data with. And remember, I mentioned to you, now NIMC gives you the ability to edit certain information, not everything, to a certain extent. Yes.
So sorry. You know why I asked this question? Sorry, I'm a journalist, and we always probe so that we can have solutions to problems, because there should be no basis for shifting blame. But when you are getting money, no, you are not holding anybody responsible. Well, when there are problems, we want to be shifting blames. If that will protect, that will ensure data protection, somebody must be held responsible. If I'm sending the USSD from my MTN line and the same information will be provided through MTN, then MTN must have a responsibility in the procedure.
But in that instance, I'm more of a processor and probably not even a primary processor, really. That entity in the middle is more of the primary processor. And then your NIMSE is actually the data controller because they sit with the data and they are completely responsible for protecting that data. So there's
just take the message.
But I remain guided. I take that feedback.
Thank you. We have another question over there and one here. So we will take these two questions, then we'll take a short break and we'll move on to the next item on the agenda. Let's have ladies first. Can we have ladies first? Thank you.
Good afternoon. Thank you for the practical section. At least knowing how interconnection works makes more sense now. So you spoke about knowing how to charge, at least for the regular calls. What about for voice over internet? Because with convergence now, we know that, okay, everything now happens via maybe your data and all. So what has been the challenge? Can you share some practical challenges and how the telecommunication providers have been able to resolve this issue, particularly with respect to everybody now make WhatsApp calls from Nigerians to Canadians and all. So that's my question. Thank you.
Okay, thank you for that question. So basically you're referring to voice over internet protocol using platforms to make these calls. Over time, and I believe Sadat had explained this, that with the evolution in the digital space, the traditional forms of communication are more on the down low. So you would see even from the number of calls that we're getting and the revenue, it's reducing for regular calls and SMSs. Because like you explained, most people are a lot more comfortable now making calls using the OTTs. We call them over-the-top services, OTTs. So for us, that is a big deal for us because it's declining revenue, but at the same time, we're still having to reinvest in infrastructure at the same level or even a higher level to be able to maintain this. So the OTTs ride on the existing telecoms infrastructure. And one of the things that we have been raising with our regulators and stakeholders in government is that there's a need for the OTTs to contribute to the investments required for the infrastructure they're riding on. Because what we, to a large extent, would say gets out of that is just that you buy data. But is that sufficient to provide
the level of quality of service and infrastructure that we have to put in place for those platforms to be able to ride on? But not always. Not always. So for us, that has been an issue. Has it been resolved? No. No, it has not been resolved. It's still an ongoing issue, an ongoing discussion. There's also the conversations around the fact that there are many times when you have issues with the OTTs, but you hold the network service provider responsible, even though it's not our platform. They're just riding on it to provide their own service. And so there's also been conversations around the regulation of OTTs. Can you hold them to a certain level of quality of service? Because the way they hold us for quality of service, you will not believe it. I'm sure maybe some people got, I don't know if anybody in the crowd had gotten like a reimbursement of some of your airtime because they said your quality of service was bad. Oh, yes. Mm-hmm. Oh, yes. Yeah. It was in billions. Mm-hmm. So we are being held responsible for quality of service at such a stringent level. You will not believe it. Oh, well, I beg to differ. But yeah, so for us as well, I know we've had those conversations around regulate the OTTs, ensure that there's a certain level, at least a threshold of minimum level of quality of service that they're providing to their own customers. Allow them or find a way for them to be able to invest in the technologies and infrastructure they're riding on. So those conversations are still ongoing. And of course, the OTTs to a large extent, they are the future. telecoms has evolved again once more. If you see it, it's never ending. It's going to keep evolving. Even the OTCs you see the way they're operating now does not mean they're going to be operating like that in the next 5 to 10 years. Yeah. So I guess I'll say it's an ongoing conversation. We partner with them, of course, for them to be to ride on us, we partner with them. But that's a conversation that's still just ongoing, not resolved yet.
So we have one more question from here.
Good afternoon.
Good afternoon.
My question is with respect to transparency.
Okay.
Most of these service providers, when we make call, for example, just immediately after the call, you tell us, you spent 11 seconds on this call, the tariff for this call is this and this, right? But in recent times, you guys make much more money off data. What do you call it? Data bundles, right? Mm-hmm. We spend thousands of naira buying these data bundles, but then you guys don't tell us how much we spend. You just, a day to when it expires, you tell us you have 500 MB remaining. So when the last time this conversation came up, I think one MTN representative gave the excuse of background applications that uses cache and and cookies. So these cookies keep running. What I'm just saying is simple. The same way you're transparent with, you spent 11 seconds on this call, and for that 11 seconds per second, you spent this amount. Just tell us, you spent so and so amount. Yes, so it's easier that way. So we know that when we use or when we buy data bundles, right? This is the tariff that I'm using. So I don't think that, MTN is just eating my money and I'm not seeing the value for my money. Which is why most Nigerians are now using the option of Starlink. I know I'm spending 50,000 naira per most Nigerians. Starlink and others. So in advanced climes, for example, like the United States, what they do is for a time frame. They buy data bundles for a month or 2 months. That infrastructure will be more expensive for the average Nigerians. So it's not looking as though most service providers hide under the umbrella of just buy 500 MB, 2 gig, and they exploit Nigerians because they just tell you have 200 MB remaining, you have 500 MB remaining. So my question is this: what infrastructure are you putting in place to ensure that you are transparent enough to satisfy the consumer protection requirements? That you have to tell your consumer that this is how much you charge them for what they have gotten.
Thank you for that question.
Thank you. I hope.
Statement. There's more of a statement. So first of all,
we are transparent. I want to just establish that from the very beginning. For every single bundle or tariff rates that you sign up to, there's an approval from the NCC. We are that regulated. We have to get approval before we can even change. Let's even say you're on a particular tariff line and want to change it. We have to get approval again. We go back to NCC. So it's a never-ending conversation. We're back and forth, back and forth, back and forth. And before we implement these on our billing systems, you must send that approval to your IT teams to implement. They will not implement without that. And I'm just giving you like an example of how things work internally in our own teams. So they must cite the approval before anything is even done to the billing system. But beyond that, the NCC has even gone both the NCC and even my own particular organization, the NCC conducted like a billing integrity audit. So they do quarterly audits generally every time. That's a normal thing for us in the regulatory space. But beyond that, there was a time when they actually commissioned a full-scale billing integrity audit because customers were complaining and they wanted to be sure that everything was being done accordingly. But do you know that before the NCC even commissioned theirs, we had done ours internally? We had actually gotten an external consultant, had them come and audit our billing systems to be absolutely sure that everything was being done properly and we were fully transparent and we're implementing tariffs as approved. That's to show you how we don't play around when it comes to transparency, when it comes to my own organization. I can't speak for any other one, but at least this organization I have worked with, we hold ourselves to the highest standards. I know that this may not play into the narrative, but we're that serious about it. We don't play. In terms of you being able to see your transactions. Now, data is a bit different from voice and SMS, to be honest. They don't work the same way. And I think that's part of the problem. But you can, actually. Do you have, for instance, if you have MTN, do you have my MTN app? Yeah, I was going to say that. You know you can go and check like your data consumption, even on your phone. There's parts of it where you can check your data consumption. No, it shows you which apps are consuming your data. Truly. You can check. I just can't remember how to get there, but I will figure it out and let you know. And it will show you how the apps are consuming data. And that conversation around background consumption of data, it is true. I know that it may not apply to you specifically, but it does apply to a lot of people. Most people are not aware that your phone is updating all sorts of software in the background. They don't turn them off. And then they come and they say, oh, but you stole all my data. And then when you go back and you look through every single thing, you realize that the data was not stolen. Your data went to exactly where it was supposed to go to, based on what apps you had on your phone. But if you still have issues, you have every right as a consumer, honestly, to reach out to your service provider and ask them and lodge that complaint. Let them take a look at it for you. I'm not sure that you found that satisfactory, but...
So there's another question. But it's going to be very short. And it's because it's law corridor. All right. Can we have the mic over there? Antonia, thank you so much for that response. Yes. And just to add to what she said, I was just going through the order paper for the House of Representatives today. There's actually a committee sitting today at 3 p.m. on quality of service regarding telecommunications. So what she said about quality of service is not just a policy discussion. It's actually something that is being taken seriously.
And then, sorry, just to add, you should be getting what we call an end-of-day daily data notification.
Do you get that? You should be getting that because it's actually required by the NC. We send that every day to let you know how much you have consumed that day. We're sorry, but we're required to send it to you. And so we do. Even before it was required, we were already sending. Until it was afterwards, it was now required. Because we're trying to address this issue as harmoniously as possible and keep our subscribers happy. That's why we do it, so that you know how much data you have consumed in each day. So you're not confused or you're not surprised when your data plan has run out.
All right. Okay. Over to you.
Sorry, good afternoon. Yes, no shades intended. My question is not relating to poor people. So mine is with regards to El-Rufai's situation. We're listening to their conversation, particularly to the fact that there is this perception that when you make calls over mobile networks, the people believe that at the back end, our conversations are being listened to. One, how true is it? And two, what are the platforms in place to ensure protection?
And I want to add, it's good that we also have an expert in national security in the room,
yes,
since the conversation seems to be veering towards that direction.
Okay. Me? As has been stated, it is a national security issue. However, we do have lawful intercept obligations, right? If you look at it, you'll see that we are obliged under our licenses and also under the regulation itself that allows for security agencies to be able to lawfully intercept. And I'm emphasizing lawfully because there are actually requirements for how you can intercept. And of course, that falls under national security because that's not our purview. But in terms of recording, just look at it. Let's look at it this way. Do you think we can record? So we have over something million subscribers. Imagine that everybody made at least maybe 5 phone calls in the day. Do you think we have the space to record all those conversations? No, I'm just asking. No, I'm asking. Truly, do you think we have that space? We don't have. I'm just going to tell you now, we don't have it. What kind of back-end information and what kind of problem? Yes.
And the communication was made via a voice call.
Yes.
When there is need to provide that evidence.
So the substantive conversation.
When neither party has any record. Can MTN provide that information?
No, we can't.
We can't.
No, we can't. We actually can't. For us to have that, that means we're recording it. We don't. We can't. if you want, we can provide you with your call data records, which is basically just shows that you called this person at this particular time. The conversation lasted for 5 minutes and 37 seconds. We can show that. But that's call data records. We're required by law to have those. But that we can't.
Thank you so much, Antonia. Thank you also to our audience. These questions were very insightful. They were very engaging. And I'm so glad that we were able to do this. Antonia, please, before you go. Yes. Can we have an usher help Antonia with this? That's okay. Someone will help you. You've done a lot. Thank you. All right. And I would like to invite Mr. Adatu Hamu to the stage. I would also like to invite to the stage the managing partner of Law Corridor, Mr. Henry. Please come on stage. And we're going to present a token of our appreciation to, please come this way. I'd also like to invite to the stage the chairman of the organizing committee for this symposium, Ms. Safia Mohammed. Please come on. Can we give her a round of applause, please? Thank you. All right. So Safia and Mr. Henry are going to be in charge of giving the presentation today.
Hello everyone, good afternoon. Thank you for being here. It was very easy to decide who to call on to join this conversation. Saadata Amu has remained one of the foremost practitioners in technology. So when we decided on this topic, it wasn't difficult to decide that she was the choice. And I mean, you can see that she got the 10 rounds of applause, which is well-deserved. 12! Okay, which is well-deserved. So you see, she has exceeded our expectations. And we thank you so much for making time to come. Thank you, and thank you for sharing your knowledge.
Basically, on behalf of the Nigerian Bar Section on Legal Practice, this award of appreciation is presented to Saadatu Hamu Aliu in honor of your distinguished contribution as Speaker at the Technology Law 101 Introduction to Telecommunications and Technology Practice. This day, the 22nd day of July 2026. Congratulations.
Okay. I mean, you know when we're talking about telecoms, you know who comes to mind, right? And so having MTN send someone all the way from Lagos, you know that this is not an easy feat. And you can see how engaging the conversation has been, how much she has taken her time to answer our questions. A lot of us didn't know so much, but she has enlightened, she has enriched us. So we thank you so much, Ms. Antonia. And she was here very early. So thank you again for coming. Thank you. And we know that we're going to engage you. So please be ready. And let me add that she was ready to share a lot of resources with us. She was ready to bring so many speakers. So we thank you, and we are going to utilize this at the right time. Don't worry, she has us covered. She has us covered. Thank you so much.
Okay, so on behalf of the Nigerian Bar Section on Legal Practice, this award of appreciation is presented to Antonia Ogudikwe Ayendele in honor of your distinguished contribution as Speaker at the Technology Law 101 Introduction to Telecommunications and Technology Practice. This day, the 22nd day of July 2026. Congratulations.
All right, so we will now take a group picture. Can we have the members of the organizing committee on stage, as well as our other speaker, Mr. Emmanuel, just so that we make sure that and Mr. Ajibola. Let's have a quick photo session. After this photo session, we're going to have a family picture downstairs. That will be at the end of the event. Yes. Thank you very much. Thank you. All right. So I really appreciate the fact that everyone has taken out time from their busy schedule to be here. Thank you again for being here. We've all been sitting down for the past couple of hours, and it is medically recommended that when you have been sitting down for a long time, please, with the exception of Antonia, because she has been standing, when you've been sitting for a long time, we need to stand up and stretch our bodies. Now, I am well aware that we are in a bit of a confined space, and there might be people next to you. We don't want anybody hurting the other person. So we have come up with some improvised exercises just to get the blood flowing. So please, if you will indulge me, can we be upstanding? Except Antonia, unless Antonia wants to exercise. All right. So what we're about to do is called the 5, 4, 3, 2, 1 movement reset. We're going to reset our bodies. Don't worry, it's not going to be anything to strain us, but I promise you after now, the heart will be pumping properly. All right, so we're going to start with 5 shoulder rolls. Shoulder rolls goes like this. As if you want to prepare to fight somebody. Yes. Yes, you can also do it forward. I'm sure we've done more than 5 by now. I can see that we're all enjoying it. So we needed this and nobody asked for it. Okay. Now we move to 4 side stretches. Please don't raise your hand. Just do like this. Okay. Beautiful. Now we're going to do 3 gentle torso twists. Here, this is your torso. We're going to twist like this. Yes. And now we're going to take 2 deep breaths, as deep as you can. Are we ready? 3, 2, 1, go. And out. Again, in and out. And we're going to end with 1 gentle squat and sit down. 1 gentle squat and then sit down. Beautiful. How do you feel? How do you feel? Refreshed, energized. Somebody said there's no difference. I beg your pardon. You will present evidence to show that there's no difference. Because when we were doing that shoulder roll, I heard some. All right. So thank you so much for that. We will now move on. Okay, we were going to move on to the next session, but I see that the speaker stepped out briefly.
Just lay about without a care. You're not lonely if you don't feel alone. Won't let pressure get the best of me. Fight your wars, lose at some, fight some more. Don't be scared to get lost and be found. You're that someone you think you're looking for. Let the fire burn just like before. For the first time, God shall be without a face. For the first time, God shall be without a name. Will no longer look for self in every mirror. For the first time, God is in your mind. People come, people judge, people go. Some will say it's each one to his own. If you go naive, you go no. Let bygone be gone. Oh oh. For the first time, God shall be without a face. For the first time, God shall be without a name. Will no longer look for self in every mirror. For the first time, God is in your mind. In your mind. I love to be all that you want me to be, but I'm not the same man that I used to be. Many times I ask myself the question why. Why you stay when you smile, it makes me wonder why. Oh, c'est qu'on va I know it's hard to walk away from what you know.
All right, we're now moving on to the next item on our agenda for today, which is a fireside chat. This fireside chat is going to be a discussion on the interrelation of technology, media, and telecommunications in the new age, and it will address socio-legal challenges. Our speaker for the fireside chat will be Mr. Emmanuel Edet. Before he comes on stage, please permit me to read a brief profile. Mr. Emmanuel Edet is currently the Acting Director for Regulations and Compliance at the National Information Technology Development Agency, NITDA. He specializes in policy development, compliance, and regulation in information and communication technology. He's a distinguished legal and technology policy expert with over 2 decades of experience shaping Nigeria's digital governance landscape. He holds an advanced degree in computer and telecommunications law and has obtained certifications in internet governance, e-government strategy, information security standards, artificial intelligence deployment, and cybersecurity policy. His contributions extend beyond Nigeria, having served as a fellow at the United Nations office in Geneva and collaborated with the Diplo Foundation on inclusive digital diplomacy and capacity building for developing countries. He's also a member of the Government Advisory Council of the Internet Corporation for Assigned Names and Numbers and a trustee of the Nigeria Internet Registration Association, NIRA. He's a very regular speaker at global and national forums and a strong advocate for participatory policies that promote Africa's active role in shaping global technology regulations and ethical digital policy. When he's not working or speaking, he enjoys playing video games, spending time with his family, conducting research, and traveling. Ladies and gentlemen, I can tell that you have enjoyed listening to his profile. And I can tell you that having known and worked with Mr. Edet for, Mr. Edet, is it up to a decade now? Yes, I can proudly say more than a decade. Everything I've read is actually true, especially the video game part and the speaking part. Yes. So please, ladies and gentlemen, put your hands together for Mr. Emmanuel Edet. And joining him on stage for this fireside chat is Mr. Ganiyu Ajibola Bello, who is the Deputy Managing Partner at Law Corridor. Please, a round of applause for him as he joins Mr. Emmanuel on stage. Please keep clapping until he comes. Ladies and gentlemen, please, my profound apologies. He has a profile and I must read it, even if I have to paraphrase it. Mr. Ganiyu Ajibola Bello, ESQ, LLB, BL, LLM, PhD, is the Deputy Managing Partner and Head of Corporate Department at Law Corridor. He's a philosophical lawyer with a penchant for legal jurisprudence. He's meticulous and he pays keen attention to the essence of law and the purpose it serves to humanity. He has served in the Nigerian public sector as a legal assistant to a judge of the National Industrial Court of Nigeria for several years, upon which he gained experience, expertise, and accordingly distinguished himself as a specialist in the law of employment and labor relations. Ajibola is a dispute resolution specialist. He also offers legal advisory on corporate and commercial practice, as well as property transactions, natural resource law, and policy and general regulatory issues. Ladies and gentlemen, Mr. Ajibola is also an accomplished author. He's the author of a textbook titled Modern Nigerian Legal System, which is currently a recommended text at the Nigerian Law School, as well as several tertiary institutions in Nigeria. He also has to his name several other publications on topical issues as published in articles, journals, and online publications. Ladies and gentlemen, an accomplished lawyer. A round of applause for him, please. Thank you so much. So I will now hand over to Mr. Ajibola for the fireside chat.
Thank you very much, moderator. I must also add to the fact that I witnessed our speaker here playing games on his phone. So I agree that he's genuinely a tech lawyer, in quotes, because we don't really want to have ourselves limited as lawyers. But I mean, for the fact that I was seeing him playing Sudoku, as this man is really into it. So thank you very much for the fireside chat. We want to just have some discussions relating to some of the topical issues that affect the intersections of technology, media, and telecommunications. I'm very glad that the presentation made by Ms. Sadia Aliyu was very, very expository. She had given us a hint as to some of the interrelations between several institutions. She, of course, mentioned NIDA, where you happen to be the acting director on regulatory and compliance. So I think I should start with my first question about what your the mandate of NIDA is for the purpose of young lawyers who might want to understand how to navigate regulatory compliance. So what the mandate of NIDA is, if you can just give us a little exposition as to that.
All right, thank you very much, and good afternoon to everyone. It's my pleasure to be here, and thank you for inviting NIDA. You didn't invite me, you invited NIDA, and NIDA decided to send me. The interesting thing about NIDA is that NIDA was created in 2001 by the then President Obasanjo's administration, and the whole essence was that the government identified information technology as a good vehicle for economic development. And so they needed an agency to propagate the use of information technology in Nigeria. And the target was to make Nigeria the biggest consumer of information technology in Africa. Well, it goes without saying we are the biggest population, so naturally we'll become the biggest consumers. And eventually in 2007, the National Assembly passed a law establishing NIDA. Before then, NIDA was an agency or a parastatal under the Ministry of Science and Technology. And so as government continues to evolve, Ministry of Communication Technology was created, which has eventually metamorphosized into the Ministry of Communication, Innovation and Digital Economy, which we have today. And so in 2007, when NIDA was now established as a legal entity, it was provided with powers to create framework standards and basically regulate information technology, which was for us then a very, very, very interesting task. And as part of the legal unit of NIDA then, it was really difficult for us to translate from a developmental agency to a regulator. But as part of our mandate also, development was there. And so we were basically referees and coaches in the same environment, so it was a bit difficult. But as time went on, we had to legally reinterpret the position we're placed into, and today we can proudly call ourselves an enabler. More or less, we regulate for the purpose of development. And so our work is basically to look at the IT sector, identify potential markets, create regulations that will make those markets provide the economic activity that will benefit Nigerians. In a summary, that's what we do. And then we also identify areas where the use of technology may create harm to those who are using this technology, and set out the necessary framework to ensure that those harms are mitigated in such a way that that technology can be used in a beneficial manner. So we are just your friendly regulator who basically use regulation to enable markets and develop information technology in Nigeria. That's just a summary.
Thank you very much. Talking about regulation, I know there's a looming judgment coming up between a matter between NCC and FCCPC over. Yeah, so is there any area of overlap between what NIDA does in relation to maybe some other regulatory agencies? Any overlap that lawyers might need to be wary about?
The regulatory space for what you would call information and communication technology or digital technologies in Nigeria is quite interesting. I would like to look at it as more of a layered environment that will probably create nightmares for everybody who wants to play in that environment. And that's why lawyers should be in that environment, so that you can help people navigate through that environment. So I'll give you a typical example. You know, they usually say that we are ministers at the temple of justice, right? So you have this picture of a temple where you have your pillars, you have your doors, you know where to go to. And that's what law is all about, certainty, boundaries, and everybody wants to know, what does this mean? How do I use it? Now, when you come to the technology space, it's totally different. Imagine walking into the building and they are still constructing the doors, and you get to that door, it has changed to a wall, and everything is just moving and you get confused. That's how the regulatory space for technology is, because innovation changes almost every second and it's difficult for rules to catch up. So instead of you using rules to chase technology, you have to create frameworks and boundaries in order to ensure that the technology doesn't cause harm. And that's where we find ourselves in terms of the ecosystem in Nigeria. So if, for example, you want to set up, let's say, a software company, first of all, you have to register with the CAC. That gives you the legal status. That's number one. Number two, if you want to provide services to the government, you have to come to NIDA. Let's evaluate what sort of things you're doing and how it affects other existing technology solutions in government. Or maybe perhaps on top of that, you want to do telecommunications, you have to go to NCC. And if that's your app has a banking feature, you have to go to CBN. Or perhaps you have some digital assets contained there, you have to go to SEC. And then after having done all this, FCCPC is waiting for you to make sure that you do not defraud people. So that's how complex the environment is. So you have several layers of compliance that you need to stick to if you want to operate in that environment. So it's left for you to decide how you carve out your niche and identify who has control over the niche I am working with, and you go ahead and do the compliance. So it's very complex. It's almost like a moving target, and that's why we need to understand that space before we dive into it.
I think that automatically explains the overlap, because for a lawyer, you have to determine the specific area that the technology is most prevalent, and then you can tell what organizations you're going to. And naturally, the ones relating to NIDA can then be sorted, and then the one by NCC and FCCPC. That's just basically what you mean. Now, if you stream that into the issue of, drawing from the issue of overlap, and then you look at the fact that issue of compliance will naturally have to come in, what area of compliance do you think, mostly exposed and lawyers need to be, very much more concerned about, particularly when it has to do with NIDA?
Particularly when the thing is, in terms of business practices, NIDA doesn't really bother you in whatever kind of business that you carry out. It is only when your business has a technology component that affects the public that's when we become interested. Is your technology up to standard? So take, for example, you provide services to schools and you store their data. What happens to that particular data? That's where we are interested. We don't care about your business. We don't care about what you do. You have your primary regulator. That's not a problem. And this creates a lot of issues around compliance. So first of all, you need to get licensing to perform whatever service that you want to carry out as far as that is concerned. Once you get those licenses, if you're dealing with personal data, you have to go to Data Protection Commission, which is one of the legal frameworks that NIDA worked hard in establishing in Nigeria. Then once you get to the NDPC and you've finished your compliance, you have to have your security under the Cybercrimes Act. Very, very important. Make sure that if you're storing things digitally, you have the adequate standard security that is required to ensure that those things are protected. Again, I mentioned FCCPC, which is very important, and any other regulator who you intend to operate in their space, they will definitely come after you. If you advertise, the advertising practitioners will come after you. Whatever you do. So it totally depends on where you want to exercise your business model. You need to identify who is the regulator in that space and what can we do to comply with the requirements of that space. So for us, NIDA, we just make sure that your technology does what it says is going to do. I'll give you a typical example. Recently, we worked with the Nigerian Revenue Service. That's what they call them these days. Yes. Sorry, I'm still trying to transit from FRI. Yes. So we did what we call electronic invoicing system. You'll soon hear about it because your clients will start hunting you down now. What it does is that the electronic invoicing system is just a basic system that allows machines talk to machines and generate invoice for payment. So this gives the National Revenue Service the ability to track the volume of transactions which you're carrying out, and you get the tax bill without any question, because there's evidence of your volume of transaction. You won't argue over the tax bill. Anyway, so so for us in NIDA, that information on volume of transaction, that data is not just for tax purposes. We want to understand the volume of transactions going on. We want to understand the types of transactions. We have also signed off to the international standards, PEPL, to also watch what happens for international transactions as well as our Africa Free Trade Agreement activities. So for us, the essence is to have the data on transactions to understand what we should plan for. But for FIRS, it's just the tax. So what we did was we agreed with National Revenue Service and said, okay, for everyone that signs up to be a service provider under the e-invoicing system, they must meet a certain standard. Now, the National Revenue Service does not have the knowledge of technology that is required for this. So they rely on us to accredit those who provide services to them. And so we do that. I think is a 2-year license. We give you a 2-year license to provide the invoicing service, and then we audit you and ensure that you can continue to run the service. So that's a typical scenario of how we collaborate with other regulators to ensure that technology serves the purpose of their regulatory spectrum.
So does this mean that after the relation with NRS, that would then translate to private businesses as well?
Exactly. Exactly. NRS actually regulates private businesses in terms of taxes. Yes. So at the end of the day, every private business, they call them large tax clients. Every private business will have some form of what you call electronic invoicing system that they will run. So, you know, NRS came to us and they had a nightmare. And their nightmare was people are using Instagram, Facebook to do transactions, and they cannot catch them for tax because they are using their personal accounts. I mean, it's easy if it's a company account. Any money that comes in there belongs to the company, so you can tax. But when an individual says, I'm unemployed, and then he's selling things on Instagram and making millions of naira, and he still claims he's unemployed, it's a nightmare. So eventually, before you carry out any transaction, you have to show an invoice. Eventually we'll get there. We are just starting. And once you show that invoice and it's a commercial transaction, it becomes a taxable activity. So it's basically trying to use technology to help them deliver on their responsibility as regulators.
Wow, thank you. You see this notion about the data collection, and I recall we had a client who had an intention to create a sort of technology that resolves kidnapping in schools so that it can interface all the school officials, educators, the cleaners. There's data everywhere. So you could also regulate in such a way that anyone who has worked in a school before and changes location to work in a new school, if the person has any record, you will naturally see it on the data. So there's a synchronization going on with Ministry of Education, with the National Security Advisor's Office, and DSS. You know, so this interface, for instance, when a person comes with such technology, you have the overlap and all the connections going on with both the FCCPC, the NIDA, the NDPC. You know, so I think that explains in a little way to me personally, how that overlap also comes in. Now, let's move away from regulation a bit and see socio-legal issues, because I mean you threw one into the air just now, talking about the fact that someone is selling something on Instagram using personal accounts. We know we have TikTokers who, I mean, just basically being an influencer, they are also making revenue from that. But beyond the revenue aspect, which concerns NRS, the issue of interlink between technology, intellectual property, and data. So earlier on, we're discussing the case that affected the Learned Sikh, Femi Falana. I know that I personally handled the one relating to Seun Okinbaloye. There was a time when it was over the news that he was, the government had picked him and all of that. There was just one very funny news about him then. Made from deep fake AI. He was advancing a fintech company. The fintech company has, at the back end, an account provided that, if you invest here, you make certain monies, and Seun advanced it. And we found out when we did the check, there's an Israeli behind, that fintech company. So ordinarily, that stretches the narrative concerning the interlink between NIDA, Security Advice Agency. You look at all of that space, and then you're wondering when that technology is being created, to what extent is there a relationship between the NDPC, NIDA, the FCCPC, every other agency that relates to security, on how technology sort of is used in a way that it protects the ordinary citizens? Because that way you're trying to remedy something that has really, really gone bad. There's almost no prevention for it to happen. You're chasing the remedy rather than chasing the prevention. Is there anything NIDA is doing to sort of forestall? I know, yes, the platforms are there, Facebook, Instagram is there, and telecoms is on one end, managing all those issues relating to Meta and the rest. But then when the technology is developed and is about to be launched, does NIDA have any role to play in this area that can be preventive first? I mean, for us lawyers, we're happy that will come, we'll litigate, we'll go to court. But then how does it happen for prevention?
Even though you are excited to go to court, I remember the first thing they used to tell us is try to resolve it first before you take it to court. And that's exactly the same approach in terms of compliance as an inbuilt feature first before you start thinking of launching. So I was discussing with someone, and I said, one of the biggest challenges we have is that lawyers are always at the back end, which by standards of technology is no more tenable, because lawyers should be at the front end to advise you before you even take the initial step. Let's take, for example, you want to build a budget app, for example, that will collect people's personal data. Right from the get-go, the lawyer should be there at the design stage, where he will tell you how to handle data minimization when you're collecting people's data. Let it be inbuilt. The lawyer should be there to tell you how to handle security. Let it be inbuilt. Because we have discovered in technology that retrofitting is not workable. Most of the time, it doesn't work. So if you don't build it as a feature from the beginning, it's going to mess you up. So now, to the issues that you have raised, we regulators have our nightmares and challenges as well. Many people don't know that, and many people don't even understand the space. And so when they run into problem, they look for a single person to hold responsible. In the technology space today, it's just not possible for you to hold a single person responsible. I'll give you a typical example. There was this incident where a self-driving car knocked down a woman in San Francisco and killed the woman, and the case went to court. And the owner of the car said, look, I didn't make the camera. The camera probably did not see the woman, so it's the fault of the guy who built the camera. A guy who builds the camera says, oh no, the camera saw the woman, but the software which was supposed to brake the car did not brake the car on time. And to be sincere to you, the legal system was confused. Eventually they settled out of court, so liability was not really given. But it shows you the nature of technology in terms of distributed liability. I know we always say it in law, jointly and severally. In this case, severally. Everybody who contributes to that system should be liable in any damage that results from that system. So like the example you made, initially, telecom companies were just conduits. They just give you the pipe, whatever you do. You know, a typical example would be like if I call somebody and say, let's go and rob the bank. The telecom company is not under any obligation because it did not suggest someone to help you rob the bank. But eventually, once you get to a stage where those intermediaries, after actually lay on algorithms that will propagate falsehood, a certain level of responsibility should be attached. So if you identify a particular misinformation and the algorithm is designed in such a way that it pushes that misinformation to 10 billion people, whoever owns or created that algorithm should be responsible, because this time it's no more an inactive conduit, it's actually an active conduit transferring that information. So I think what we should understand is that overregulation is a good thing because it covers the entire field. But where we have a problem is where regulators don't work together to address certain issues. I'll give you another typical example, which NIDA worked with the FCCPC and CBN. You know those money apps where if you borrow money and then you don't pay on time, they send your name all over the place. Then we're still dealing with data protection. NDPC had not yet been created, and eventually it was created later, NDPA. And it was a problem that we needed to address. First of all, the Money Lenders Act is based on states. It's state-based. So it's not a federal. And so, but meanwhile, all these apps were federal-based, and it was a big gap. CBN does not deal with money lending, so it was a problem. So now, here you are with all your boundaries, and yet somebody squeezed through the boundary and committed a crime. So we had to come together with the CBN, and eventually we made a regulation through the FCCPC on customer protection, which eventually data protection came in, and we were able to stop those things. That's why you don't see them anymore. And what we did realize was that a lot of those apps were not Nigerian-based apps. They came from a culture where shame was an issue. So in their culture, if they say you are a thief, you should be ashamed and you go and redeem yourself. They misinterpreted it in Nigeria. Nobody cares about that. But what happened as an example there is that several regulators were able to work together to plug a gap. And that's a model I think all regulators should do, because that era of protecting your turf is totally gone because everything is technology based now. So you need to use technology to do your regulation, and that's what we think it is. So if we are talking about somebody who is using social media, we face the first challenge. 90% of the social media companies are not Nigerian companies. That brings up the international aspect. So how do we handle it? That's number one. Number two, if you block, using telecommunications, for example, block these social media companies, they are actually providing an economic activity in your country. It's like throwing the proverbial baby with the bathwater. That's another thing. So we have to come to a conclusion. And in NIDA, we tried what we call the Code of Practice, which was basically a soft law. We got together with all the social media people and said, oh, look, this is a litany of Nigerian laws. You have to obey them. And so at the end of every year, you must give us a report on how you have complied with these various laws. It was just, it's just an experiment for us because we want to test and see how these things work. Unfortunately, a lot of people don't understand that space. Oh, you're not sanctioning them. You're not. How do you sanction a company that is not based in your country? Remember when Twitter was blocked? That was a sanction. Who cried? Still the same citizens. So how do you strike that balance? The only way you can strike that balance is to develop a soft law, run that soft law with these people and find out where the pitfalls are, things to address, and eventually you make it into a legislation that will help you in the long run, which is what we are working on. I think we are working on an online harms bill right now to move forward what we did with the code of practice. So at the end of the day, technology is dynamic. Lawmaking and regulation should also be dynamic. Technology is innovative. Lawmaking and regulation should be innovative. I remember when we did local content and say, oh, if you're a foreign company, you have to have local content in Nigeria, and so you must. You know what they did? They all registered Nigerian subsidiaries, and so there were no more foreign companies operating in Nigeria. And, you know, it was a shock to us, so nobody to regulate on that space, so we had to readjust. So there is what is called constructive compliance. Somebody wants to start a company, he just goes to the internet, Shebi, you want privacy policy. He will copy one from Google and paste on his website and change the name. Has he not done privacy policy? So at the end of the day, if you look behind the privacy policy, the guy doesn't even know where his data is. I mean, it's just like giving your key to a valet who gives it to his friend, who gives it to his cousin, and then something gets missing in the house. You don't know who to hold responsible for it. And those are the kind of things that you require lawyers to sit on the table from inception to conclusion in order to ensure that you do your compliance right from the get-go.
Interesting. Yeah. I think this should relate more with the younger lawyers. AI can create songs now. You can create a movie with AI now. And my mind is running through the issue, you know, surrounding intellectual property, and where does NIDA come in when, you know, you're looking at, first you said something about the technology being created for public use. Yeah, that's on one hand. To my mind, I'm wondering, where do you go to when it's for private use? How do you create that borderline of what is public and private first? But then, still streaming from that, I'm wondering, the relationship between, you know, technology and intellectual property, and I'm very, very glad you're pretty versatile with AI development. So how does NIDA come in when someone brings a technology to you, or perhaps the general narrative of technology being created and breaching intellectual property? I know we'll get to that area of determining who claims intellectual property, yes, but that's on one hand. Then on the other hand, when it comes to NIDA, how does NIDA play the role of checks on who owns, who creates a technology? How do we ascribe liability, rights, and benefits, and all of that? Is there any space that lawyers need to really understand this interrelation between technology development and intellectual property, especially in the era of AI?
We also have issues we grapple with, and you gave a very typical good example. We have the regulator for intellectual property somewhere, and NIDA is not the primary regulator for intellectual property. What we regulate is the technology that provides intellectual property. So that's where we stand aside. So if we need to do anything in the area of intellectual property, we need to go to the primary regulator of intellectual property and explain to them how this technology happens and what is needed. Now, having said that, I'll move into NIDA's role. One of the first things we did, which was probably about 10 or 11 years ago, is that we collaborated with the Copyright Commission. I don't know if they still have that system. The problem was that software source code, for example, in America is considered as a patent. In the UK, it's considered as a copyright. So the question was, in that kind of global environment, what would Nigeria think? How do we adjust to it? And the suggestion was, since we follow the common law rules, let's follow the UK. And so it became very important. So how do you determine that someone is the author of a software code. It became a big problem. Because you can write your code in your room, I copy it. You have not published it, and then I'll go and publish it. And who has the intellectual property? So in order to help, we had developed a portal for the Copyright Commission where if you have anything you want to register, you believe is a copyright, you go there and register. I don't know if they still have it today, sincerely, but that was about 11 years ago. So that would help you register your first interest in a particular set of codes, which you can now use to claim against anybody that violates your copyright. It was a novel thing. We had never tried it before, but we wanted to see how the Copyright Commission manages that. Now, having said that, that's just one of the ways which we can collaborate to make sure that copyright is protected. But the point here is this: with the advent of technology, it becomes very complicated. And I can assure you, personally, this is not NIDA, personally, the current state of copyright or intellectual property law is not equipped to face innovation that is coming, the one that has come and the one that is still coming. Take, for example, image rights, right? You own your face, but if I take a picture of it, the way I stood and took the picture, it becomes mine. So that image is fed into AI. Is it your image or the image I created? It becomes a question of law. So how do you protect image and identity? Yes, biometrics is considered as your personal data, but is a picture really biometric? That's another question in it. So there are very, very unique gray areas that needs to be addressed by the law. So if, for example, I use somebody's image, I use it to propagate fraud. Now, the person can think of maybe suing me for defamation, but there are certain elements in tort the person has to prove. Are those elements contained in my activity? Was it a commercial activity? Did I actually, do you even have the reputation to be damaged in the first place? That's another thing entirely. So it's kind of complicated, and I think this is where lawyers should be really, really, really interested in those gray areas, because it gives you an opportunity to redefine law in such a manner that it will help your client. So, AI. Who owns AI? AI produced music. If in producing that music, AI sampled data that is copyrighted, then it's very clear. You can easily say, oh, he took my copyright and then, what's that word you lawyers leave? He improved upon it and it became a new copyright. So I have an interest in that. Oh, so, but even if he uses voice, it trains itself on huge amount of data sets. And the problem is, if those data sets are copyrighted, that means you're using it in violation of the person's copyright. Or the person's intellectual property, so to speak. So it becomes very interesting. We had a very interesting case in NIDA where a gentleman took a photograph of Fulani and he took another photograph of Igbo and he had it in his drive. And then his friend works in NIDA in the corporate affairs department. And so we had this exhibition in GITEX in Dubai. And he asked his friend, do you have any picture that has Nigerian tradition? He said, yes. How far now? Give me now. Okay, you give me 20K, I'll give you. Give the guy 20K. And then he took it and then he blew it up in our pavilion. And when the guy saw it on the news, hey, you violated my intellectual property, and NIDA got sued for 200 million naira. Anyway, so the thing is, it was a very interesting case. I really wanted to see the end of that case, even though we eventually settled out of court. But the point here is this. Where intellectual property becomes an issue, technology makes sure that it nullifies that right. Because no matter how you regulate, technology will just find a way to avoid your regulation. AI was created, but AI takes decisions. And sometimes those decisions are independent, in quote, of whoever created the AI. But that person created the algorithm that cascaded into that decision. So can you say it was an independent decision of the machine? For me, I doubt. But that's an area of law that we need to explore. And at the end of the day, you realize that even though it's so complicated, we have to define new rights as far as human beings are concerned. The reward for intellectual property is for the author. Now the author has given agency to machines, and these machines are creating even better intellectual property than the author. So how do we address this? So while there is no silver bullet that will solve all the problems, we need to begin to advocate for a more definite stance as far as intellectual property generated by technology is concerned.
Wow, thank you very much. This reminds me of probably last time I used ChatGPT. I was saying, you wrote thinking, and I asked myself, can machine really think? But then we'll leave it at that. I want to really thank Mr. Emmanuel. It's been really enlightening. Before you drop, I'm seeing you want to drop the microphone. Before you drop the microphone, for the benefit of the younger lawyers who would probably just get into practice, really, just one last one, more like a snippet of guide as to how they will relate with NIDA when they have probably their first client. What do they do with NIDA? First, just in summary, 3 lines, and they can have it, just for the benefit of those who are online.
If your client wants a divorce, don't come to NIDA. Anyway, so the point is this: in NIDA we deal with technology standards and guidelines and frameworks. So if your clients wants anything to do with running a technology service company in Nigeria, you need to have a conversation with us. We have an approach in dealing with regulation. First of all, we enable the market. Once we enable the market, we study the market. And once we study the market, we decide how to intervene in such a way that it doesn't stifle regulation. So some of the markets your clients may be exploring is an open market, not yet regulated. That's good. In fact, sometimes it's even the people that bring our knowledge to the possibility of a particular service that needs to be regulated. That's how open the space is, whether it's from domain name to applications that run on domain names, so many things. But one thing that we are emphasizing is this: digital sovereignty. There's a challenge in definition of digital sovereignty. Some people just believe digital sovereignty is storing your data physically in Nigeria. It's not exactly accurate. Digital sovereignty is your ability to control the use of your data irrespective of where it is stored. It doesn't matter where it is stored. You know the Ukraine-Russia war? Why do you think Ukraine is still successful? Russia has literally destroyed all their infrastructure. Everything about Ukraine is stored outside Ukraine right now. So would you say Ukraine has digital sovereignty? Exactly my point. Exactly my point. So these are the kind of things that we need to have conversations about. So as a young lawyer, first of all, if your client speaks to you, you have to map out the environment where your client needs to operate in. Secondly, you have to understand who are the regulators in this environment. And then thirdly, is it technology-based and will it provide services to the public? Then NIDA would be involved in assessing that technology. And you need to also understand that as lawyers, not only do you owe a responsibility to your client, you also owe a responsibility to the society to participate in the development of those laws and rules that will eventually govern the society. So when we call on people to come and make comments on our proposed regulations, we expect lawyers who are in the field, who have experience of things that we may not be able to see, to come and make such contributions. And it will help us improve the regulatory space and ensure that every Nigerian uses technology safely. Thank you very much.
Thank you, thank you, thank you. Please, a very, very resounding, a massaging round of applause, according to Mr. Fernandez. Thank you very much, sir. Back to the moderator for questions.
Yes, thank you so much for that very engaging conversation. I know that we have some questions that we would like to ask, but before then, I've been given the very special assignment of announcing to you that there are prizes for those who were punctual to this event today. The time for this event was 10 a.m. A lot of us came after 10 a.m. After 11 even. Minus, yes, of course, and our speakers were not included. In fact, even our speakers were here early because if you think about it, someone like Mr. Emmanuel's session wasn't until, I think, almost an hour after he arrived, so that's still within time. Anyway, having said all that, there were 5 people who came early. They were the first 5 people to arrive, and we have a special gift for them. This gift is so special. I hear that it was written by the chairman of the Technology, Media and Telecommunications Committee of the Nigerian Bar Association section on legal practice, Mr. Fernandez Marcus-Obiene, aka the Fenist. I've also heard that the book is a bestseller. I've also been told that if you ask politely, he will sign an autograph for you. I am not sure whether he will sign it for free or whether there will be money involved. But he's here. So, let me begin by announcing the first person on my list, Olusegun Onimode. A round of applause, please. Sir, you can come forward for your gift. The second person is Emeka Ogbo Blessing. Do we have Emeka Ogbo Blessing? Thank you. We also have Kamarudin Onimisi Abdullahi. The fourth person is Doshima Adagusu Unguswen. And the fifth person is Amira Adeyemo. Do we have Amira Adeyemo? She's here. Another round of applause, please. I think it's at times like this that we are reminded that it pays to be punctual. Yes. It does. So thank you so much to the author for that generous contribution to this event. I've also been informed that we have 5 more gifts for the most engaging attendees at this event. I feel bad for those that have left because this is going to be tough. But there is still time to make up for it because we still have questions and answers for this last session before we begin to wrap up. So over to the audience. Do we have any questions? You have already engaged before, sir. No, I'm just joking. All right, so please let's give him the microphone over there. Do we have any other persons? Okay, we have 2, 3. Any other? Okay, so 3.
Good afternoon, everybody. Okay, so when you were speaking, you talked about the mandate of NIDA. So, but my question is coming from the angle of the commercial aspect of it, of technology, particularly the fact that we have Ponzi schemes that have been circulating, particularly CBEX was one of those schemes that affected a large population of Nigerians. So in such situation, how do NIDA come in? Do they punish to compensate the people that have suffered, or do they allow everybody to bear their brunt? Particularly as to the fact that they were not involved when they made these investments.
All right, thank you. That's a very interesting question. And I know it's born out of the fact that when people are hurt, they look for someone to blame. It's because we get all sorts of issues. But in direct answer to your question, the first thing you have to understand is that NIDA is not a law enforcement agency. That's the first thing. We regulate technology. So what you use the technology for becomes an issue. So take, for example, it has to do with investments, right? So probably banking sector is being regulated by CBN or Security and Exchange Commission. So it's their primary responsibility to ensure that people's investments are safe. Now, I do not think that was a failure of technology. If it was a failure of technology, then you can hold us responsible because the person did not meet the standards. But this is somebody who used technology to scam. Let's remember, technology is neutral. It's like a knife. You can use it to cut bread or to stab somebody. It really doesn't... the knife is not interested in how you use it. So it is those that regulate that particular conduct. First of all, did the person obtain license? If he did obtain license, then whoever gave him license is responsible to regulate the person. Secondly, I know there's a saying that buyers beware, but in technology it's extremely difficult because when you're bombarded with so much false information, there's no way you can beware or even aware of what the truth is. And so you need to be protected as far as those issues are concerned. So if the regulator in that sector failed to regulate enough and someone used technology in that particular sector, I think the regulator to a great extent should be responsible. And whoever invested, did you care to check if the person has a license to do what he says he's going to do? I mean, I won't lie to you. I've known a real knowledgeable people that have fallen prey to those things. You know, every day you browse through your Instagram or Facebook and they tell you, oh, invest $20 and you get $20,000. We would all be billionaires by now if that was possible. So first of all, the question is, you need to be aware of all those schemes. You need to have a knowledge of that as an individual. Secondly, the regulators of that sector should be held responsible for anybody operating in that sector without a license. And this is one of the things that NIDA helps those regulators do. I think currently we are working with CBN on, CBN came out with that regulation that you must make your transactional data local in Nigeria. And we are working with them to see how that can be practicable. Because sometimes you need to understand the space before you make a particular proclamation. And maybe in the next few days, you'll be getting more clarity as we deal with our cloud computing and cloud sovereignty regulations. So I would say that it's the responsibility of the regulator for that space. It's the responsibility of those who allowed it to happen. And it's really a sad phase of what technology can do and amplify. We can't punish anybody. The only people that we can punish is if we gave you a standard to follow and you did not follow that standard, then we can recommend to the Attorney General to prosecute you for violating our law.
Good afternoon. My name is Olusegun Onimode. I actually have two questions. The first is with respect to, let's say, the advent of AI in the African space, specifically in the Nigerian space. I know that at this point in time, AI is sort of, let's say, an arms race amongst nations because everybody wants to get the most developed, the most advanced version out as soon as possible. And for that reason, there's this maxim that they use. They say you move fast and break stuff. So generally, even in advanced nations, we see that the more reasonable proponents are still saying that people should move with caution. But at the same time, we're hearing people in Nigeria specifically saying that, okay, they're building their own, let's say, Yoruba AI, they want their own Nigerian AI, and so on and so forth. Are there any regulatory, or let's say, are there any guardrails being put in place to regulate this space locally with respect to NIDA's responsibilities? The second question has to do more with my own observations operating as a legal practitioner in Nigeria. What you find out, and I commend NIDA actually, because we find out that you are one of the more responsive and responsible governmental agencies. But most agencies don't act like you do. And yes, I know that you have referred to the fact that you try to synergize with other agencies, you try to synergize with other legal bodies, carry them along, and so on and so forth. But the fact still remains that we are painfully behind as far as it relates to governmental agencies and IT, technology, and so on and so forth. What do you think can be done to accelerate this process and ensure greater reliability across the board? Thank you.
All right, thank you very much. For the answer to your first question, yes, we are working on an AI ethics framework, and we are working on an AI deployment in government framework, because we have realized that AI is going to be used for a lot of government decisions that may deny people their rights or actually give people certain rights in terms of entitlements as far as government is concerned. And so we are working on an AI ethics framework, which is part of the recommendation of the National AI Strategy, which we co-created with under the supervision of the ministry with the whole AI collective. Initially, one of the challenges we faced was that when AI started, became so popular, we were basically consumers. And so it was difficult to find data sets or base that you could use, local data sets that you could use to train AI algorithms. And then, of course, those algorithms themselves were not written by Nigerians. But eventually, over the past 1.5, 2 years, Nigeria has done a lot, especially the private sector. And kudos to the private sector. They always see an opportunity and they go after it. So we did what we called AI Collective, where we got about 45 people to research on various sectors and how AI can apply to those sectors. And based on that research, we identify how we could implement AI in those sectors. But now that we have enabled the market, we are taking a step back to look at how do you regulate those markets. And the best approach, which we have identified right now, is to develop a code of ethics, where if you are deploying or developing AI, you must follow. We're in the final stages. Then we'll now invite public comments and see what the public thinks of what we have done based on existing legal frameworks, even outside the country. So that's the answer to your first question. Your second question about the deployment of technology in government. It's very interesting. The reason is that in NIDA, we do what they call IT clearance, which is basically to clear government projects if you're doing information technology. So if you want to use government budget to put in an information technology solution, you have to come to NIDA to evaluate it and then clear it for you to implement, whether it is hardware, software, or networking at some point. So based on the data we've gathered from all we have been doing, we observed a few things. Number one, the greatest fear is that most government workers believe technology will take away their jobs. And so there's a huge resistance. There's a huge resistance. That's number one. Having identified that, we came up with a program called Digital Literacy, which is aimed at educating those people and upskilling them to handle technology. We have met with a certain level of success, but you know how it is. Sometimes it's a bit difficult for you to convince someone to go for an extra skill when the person believes I can get along until I get out of here. It's a bit difficult. Those are the challenges that we face. But by and large, one other issue which we have also identified is that technology follows budget, right? If there's no budget to acquire technology, the agency will not do it. So it's one of those challenges that you need to speak to the heads of agencies on how they can deploy technology to support their systems. Unfortunately, sometimes when you have those conversations, you have somebody from the private sector jump in and wants to sell them something. And you're now looking like the person who is advocating for the technology to be bought. But over time, we have observed that ministries and departments and agencies, especially of the federal government, have begun to deploy technology in such a way that is beneficial for their daily operations. But again, there are other foundational issues such as connectivity, power, and capacity as well. And you know what they do? They now outsource it for people to manage for them. And that creates a new problem that we need to address. Because, take for example, they will get someone to do build, operate, and transfer. And the person will build, operate, and refuse to transfer because he's making money off it. In fact, there was a particular agency in the port that had this guy who built a system for them to collect money. And he got to a stage where the guy hijacked their domain and he will give them whatever he feels that because they had no existing about compliance from the beginning. They had no system where they could check how much was coming in. So the guy can collect 10 billion and declare 10 million. And then out of that 10 million, he still gives them 5 and takes 5. So those things are there, but these are a result of legacy systems. As we continue to evolve, we are addressing those issues as they come up, and eventually we'll get to a place where government will use technology successfully. But it's going to take a bit of time because of the current environment that we have. Thank you.
Thank you. Let's have the gentleman over there.
Thank you very much. My name is Franklin, and actually my question has been to an extent addressed, but just to show some, throw the spotlight on it. Well, I would say that some time ago I went home and met my cousin doing something on the computer. I'm very curious, so I asked him, what's this about? I saw all these lines and charts. And I said, tell me about this. And he said, well, this is just basically trading. You have to watch the chart, you have to watch the up and down, follow the news, you know what's going on. You can trade in coins, in currencies, and all of that. And I found it very interesting, because he said you can actually make like a lot of money within a week and all of that. So I started researching on it. I started because, I just have to know. I started researching on it, and I found that in Nigeria today, there are so many companies, or let me say persons, who are representing themselves as traders and also as trading agents. And if you go online today, you see a lot of advertising around this topic. You see show of affluence, saying that I trained this person within a week, he was able to buy a Maybach. I trained that person within a month, they were able to build their own house. You can make $10,000 within a week. You just come and trade with me. I saw multiple of these. Now, one interesting part of this is the fact that it's not just about working with a person now. They will tell you that once you're ready to work with them, they'll plug into their AI. So it's actually the AI that is plugged into your own trading platform, and then you put your own real money, and it's valued in dollars, of course. And then they'll tell you there's a demo account, and I'm sure most of us know these things I'm talking about. And then there's the real account. Life account, God bless you. Thank you. So, and then you see that what the AI does is to suggest to you, this is the best, because I actually had to try these things to know what's going on. This is the best trade. This is the next one. And they tell you, yeah. And then you invest, and then you have to, you choose that one. The interesting part of it is the AI will not tell you which one to choose. It will give you all the options, and then you must press it and say, yes, you select this one. And then it tells you, okay, how many seconds, how many minutes, and things like that. And once you select it, your money goes. And once your money goes, you don't know what's going to happen. Sometimes you make profits, sometimes you make losses. Now, the interesting part of this, and that's why I'm bringing this up, is that you can actually make profits, and then within a day, you can lose all of it. Now, if you say that, okay, this person introduced me to this thing, I want to go after this person. At that point, you will discover that that person is actually not a person. It's some kind of deep fake personnel that looks like a real person that's actually showing off this thing online. So you don't even know who you are dealing with. You are dealing with invisible, non-existing entities, and you'd have done everything you wanted to do. So my question is, this thing is proliferating over the internet right now. And there are so many AIs all over the place. All over. And this, I do not believe, I might be wrong, but I do not believe that these things are regulated. I do not believe that all of these AIs created, plugged into private persons' accounts are actually regulated. How do we keep on this type of situation to ensure that Nigerians do not continue to lose their money every day? Because unfortunately, and I say this with all sense of concern, Nigerians are very, very easy to,
Thank you very much.
Yeah, so what is the solution to this, and how can we regulate this ambit of AI?
Thank you.
I think in one word, the solution is education. It's just like asking, how do you regulate lies? It's simply not possible. But you can make people aware that if this is what you hear, it's possible that it is a lie. And that's the only way you can do that. So, I know you already know the answer to your question. We are very, very gullible. We have moved into an age where hard work is no longer celebrated. Somebody wants to sleep with 1,000 naira and wake up with 10 million naira. And he keeps doing everything to make sure he gets to that stage without even realizing that you have spent more than 1 million naira trying to get the 10 million from where you started from. I think it has to do with societal reorientation. And believe me, it's not only in Nigeria. In fact, in Kenya, they had to regulate betting apps because people were depositing their salary into betting apps. 100%, because they believe the next day you're going to get 10 times that. So it's everywhere. It's just one of those social engineering that we are facing. It just simply amplifies what already exists in the society. And so the best you can do, and remember, a lot of those apps are not even Nigerian based. So you can't even get to them, so to speak. I remember there was a time way back, that's probably about 18 years ago, when somebody registered a domain, universityofnigeria.com. And then we looked through the advert. He was teaching you how to do 419, how to steal, how to scam. We felt it was a bad thing about Nigeria, and we had to contact the American company that registered it. And they told us, oh, it's freedom of speech. So you have those challenges across borders, because what you may consider a crime in your country is not a crime in their country. So where it now comes in is, how do you educate people and say, look, if it quacks like a dog, duck is probably a duck. So you should be extremely careful when you're dealing with such instances. And I think that's the best option. People should be aware that there is no way you can invest 1 naira and get 100 million naira. It's just not possible. Under any economic activity, it's just not possible. Thank you.
So, good afternoon, sir. Good afternoon, everyone. So my question is basically from your presentation earlier, when you mentioned the soft law approach, which the agency has undertaken with respect to Meta and other international organizations. Now, with respect to that aspect, the reason why this question is very imperative at this moment, even though not necessarily related to the discourse today, is because we will not be here without security. Security is the paramount need of every human being. When you go to social media, even though I'm not on TikTok, but I think I see a lot of videos from TikTok, and the firm as a firm is on TikTok. When you go to TikTok, we see a lot of bandits and criminals parading themselves on TikTok and giving out freebies and other things on TikTok. You go to Facebook, equally there. Bandits available. Issue of telecommunications, they make calls very freely with victims and families seeking ransom and what have you. What has NIDA, NCC, and the ONSA, that is Office of the National Security Advisor, what have they done as a temporary measure while waiting for the soft law to apply? Because the soft law, it seems to be an annual event where the agencies will review and get back to us. We cannot wait for that annual review when we are not safe in our daily activities. So what temporary measures have been undertaken, particularly with respect to dealing with those, since we have access to these accounts, we have the service provider like MTN, etc. available. What is the urgent and immediate need or actions taken by NITDA, ONSA, and other relevant agencies of government with respect to... You don't want to be the National Security Advisor? It's actually a very big position. So what are you doing? Thank you very much. So that's
all right, thank you very much. That's a very interesting question. And one of the things that we grapple with is to see how we can use technology to support security. And that's a very huge thing. So let me paint a picture for you. TikTok, Facebook, Meta, as they call themselves now, Instagram, all of them, yeah, they're all under Meta. Even Google. One of the challenges you have is that you have this proliferation of access points, right? People can upload through direct satellite. NCC has no control over that. People can upload. I mean, I know there was a time I went to Ogun State for an event, and I realized that it indicated I was roaming on my MTN because I was at the border town and there was no MTN service, and so it latched into the next country. So people do that a lot. And so it creates that mask that brings additional challenge to law enforcement. So prevention is extremely difficult. However, in response, one of the things that the Code of Practice helped us do was that we found a way to talk to those service providers to give us dedicated channels for law enforcement to escalate anything that is seen online. And what they can do is to take down those content. They cannot go after the people that uploaded the content. It is now left for Nigerian law enforcement to try and pinpoint where that content was uploaded from, through which SIM card, and then go and get them. So, again, no matter how good your laws are, enforcement is a problem, right? Even though we have laws against theft, people still steal every other day, and you don't even catch up to 30% of the people that steal. That's just the way it is. And I always tell people that technology amplifies that a millionfold. And so it now becomes visible, things that you didn't see. So most instances, whenever we have now connected law enforcement directly to those platforms, they no longer pass through us. They have a dedicated communication. In fact, we don't even know about some of those people unless complaints come to us. So what the law enforcement people are working seriously to ensure that those things are not propagated. As it is, as of today, I may not be able to know the statistics, but a lot of them are taken down. Initially, we had a problem with TikTok because TikTok told you, well, they are not in Nigeria. They don't have an office in Nigeria. And so we continued engagements with them because it gets to a point where you know that the only way you can get somebody to answer you is to keep knocking at the door. At some point, the person gets tired and says, okay, what is it? And that's the approach we have taken. So not only the Code of Practice has also made sure that they give us contact person to deal with issues. Again, we have an additional problem. I can tell you that for free. When people have problem with their accounts, they come to NIDA. They will violate the rules of the platform, and the platform will delete the account. They'll run to NIDA to appeal against it. And when we don't answer, they say, NIDA doesn't do their work. So we have all those issues. So at some point, the platform told us, say, look, this line we gave you to talk to us is not for these people who own account. It's for critical national issues. So if you overload it, we will ignore it. So we also have to strike a balance. So law enforcement are actually working hard to get those people down. But till now, it's extremely difficult to acquire the kind of technology you use to pinpoint where people upload from, who uploads, and I think it's only recently that has reduced. Pre-registered SIM cards. At some point, they had close to about, 3 million or 4 million pre-registered SIM cards that could be used to commit, yes. So you block them, they bring another one. You block them, they bring another one. And they've been doing it over and over. So just as you're making those rules and trying to enforce them, people are coming with creative ways to violate those rules. So those challenges will still be there, but law enforcement is working hard to make sure that they manage and deal with those particular issues. And TikTok was a very, very, it was an issue of concern for us because we're able to deal with Google, deal with Meta, deal with all those other ones. But TikTok was a big problem because their algorithm is designed in a particular way. And since it's video, people like those kind of, it's basically video based. But we are working on that. And eventually I'm sure that come sometime in future, we'll be able to have that conversation. In fact, I think tomorrow we are appearing at a public hearing where a senator has decided to suggested an amendment of the Data Protection Act to ask the social media houses to have offices in Nigeria. But we do have our reservations about that because somebody can have an office and it doesn't mean anything. It doesn't mean anything. You serve him in his office, so what? How will you enforce it? You close down that office, no problem. That's it. So I think we need to understand what the issues are before we take steps. The person can be in America and gives you a channel and is more efficient than him having an office behind your house. And those are things that we need to actually have sincere conversations about. And that's why our approach has always been, let's engage with these social media guys. They want to make money, right? So we tell them, if you want to make money, these are the rules you need to follow. The National Revenue Service gave all of them tax code. They are paying their taxes. Yes. And you're insisting they should come and establish office, which will, okay, imagine TikTok having an office in every country in the world. That's commercially not possible. Anyway, those are issues for another day. But I think having a better understanding of how technology works, because we are still exploring. Like I mentioned at the beginning, it's like walking into a house that things are changing and you're moving. We are still exploring. So let's explore properly. Because by the time you bring the rules of existing legal frameworks and try to impose them, they will fall flat. So you can have somebody have his office here, no problem. Nobody comes to the office. Should be his office you're asking for. They don't have any employee at the office. Those are things that can actually happen. They'll constructively comply with your law, but it doesn't make any meaning. And those are issues that we need to address and have conversations about. Thank you very much, sir.
Okay, thank you very much. Please, massage. Okay, so I just wanted to add that it's even difficult to even pinpoint their venue because in addition to being able to know where some of them, they're also developing or using masking technologies that make it difficult to find out. And then in some cases, you would find, like in the case of the people that were, the Oyo people that were kidnapped, you will see that they even use a wrapper to cover. So that even law enforcement, even if you're able to, it's difficult to track where they are. So they're not, even though they might appear crude, they are using crude methods to find ways to, not for you not to be able to find them. Yes, even for payments too, I'm told, and I'm not in the NSA or NSA, but I'm told that they're even doing payments from abroad using foreign accounts that we don't have access to. So we are consistently trying to create a relationship with across Africa, across various countries to see how we can ensure that those accounts are tracked and followed up. So it's not like we're sitting down. Government is not sitting down.
No. The thing is, imagine when you're chasing a thief. The thief is more motivated in escaping you than you are motivated to catch the thief. Your law enforcement people work 9 to 5, and this criminal work 24 hours. There's a mismatch there in terms of capacity. I can see one more hand. Are we taking one more question?
No, we're not taking any more questions at this time. We're severely out of time.
Well, my time is saying time is to 12.
So, we've come towards the end of our symposium today. I don't need to ask if we've enjoyed ourselves. I think we all have. Not yet, please. So, I'm told that there is a special presentation to be done by Fernandez and Henry. So please, if you will come on stage for the presentations.
Okay, let's do this one first. No, let the speakers wait. Let people be waiting for a special presentation. So which one do you want to do first? Bring this one first. Where is the bag? Okay, so, well, Safia does better at this talking thing than me. Safia, please come and talk.
Now, just like you said, Mr. Emmanuel, we invited NIDA. And we thank the DG of NIDA, who in his wisdom knew that the best person to speak to us, not just speak to us, but to educate us, is nobody other than the passionate Mr. Emmanuel Edet. And to that we say a big thank you. He was overwhelmed. Today he was busy, but he had to make up time. He had a meeting up till 12 p.m. and that's why you notice he walked in at about 12 o'clock. He had a meeting. But he knew that this passion he has to show us. And we thank you. We appreciate you. Thank you so much for sharing your knowledge with us. On behalf of the SLP, we present this to you. Thank you.
Let's stand there. Let them snap us to it. Okay. Where's the box?
So if there is something we have learned on the journey of this conference planning, it is that there is no need for protocols. And that's what happened when we met Mr. Ajibola here. We were trying to get a meeting with Law Corridor, but the minute we dialed him, he broke everything. He broke all the fire, he broke all the ice, and he joined us in planning this symposium. He was available at our beck and call, and you can see that the choice for this fireside chat is very deliberate. You can see the passion he has displayed. So we thank you so much for not just displaying your passion, for encouraging us, and for he supervised this organization. Yesterday he was here up to 7 p.m. He made sure that he taped this place himself. So he not just supervised, he did the work, and we thank you specially. And of course, we'll be back. So on behalf of SLP, we thank you. Thank you so much for allowing us to enjoy from the wealth of your knowledge and the hospitality of your office. Thank you.
Oh, they've done this.
Okay. So how about
there's one. No, we already done group pictures.
Okay.
There's one. Bring the other one. Bring that one. Bring that one. Bring that one. Bring that one.
No, this should be complete.
No. He has his own.
Okay. I wanted to confirm.
Now, it is not every day that somebody will say, I'm going to partner with you and give you everything that you're looking for and more. Even the things that you trick them, that they knew that you're tricking them, but they still gave you. So, on behalf of the Nigerian Bar Association section on legal practice, I'm happy to present. Okay, do you want your team to join me? Okay.
Law Corridor, please. Some of us who are here. No, yes. Join.
So, sorry, I want to
Yes.
So, on behalf of the Nigerian Bar Association section on legal practice, I am happy, excited, elated. What's the other word again? Bamboozled, flabbergasted. What again? I will not say intoxicated. To present this award of appreciation to the managing partner of Law Corridor on behalf of the firm Law Corridor in appreciation of their invaluable partnership, very generous supports, and contribution to the success of this event. Thank you very much.
Thank you very much. Thank you.
Thank you very much. You want to say something? No, you say after. No, you say post event. So there's more. Please. There's a special. No, Malga, please. We are together. So I'd like to invite Miss Ayanfe Victoria Adeyeye. Is he here or Yeye? You're going to present it.
Do I need to read it? All of them? Okay, very well. A certificate of service, MBA section on legal practice. This certificate is proudly presented to Ayanfe Victoria Adeyeye, Secretary Planning Committee, recognition of your exceptional dedication and invaluable contribution to the successful planning and execution of Technology Law 101, Introduction to Telecommunications and Technology Practice, held in Abuja on the 22nd day of July 2026, organized by the NBA-SLP Technology, Media and Telecommunications Committee in collaboration with Law Corridor. Congratulations. Thank you.
Usman Chamo.
Mr. Usman Chamo, I will please summarize a little of this contents to basically say that this certificate of service is presented to Mr. Usman Chamo, Member Planning Committee, for his contribution and recognition of his service in the success of this event today, being the 22nd day of July 2026. Congratulations. Sunday Adebayo. Sunday Adebayo, please. He's coming. See him at the back, please. Comforter. Mr. Sunday Adebayo, congratulations on the certificate of service as member planning committee of this event today. Congratulations.
My enemy.
Chidera. That's actually my sister's name. So, Chidera Ike Okonkwo. You don't like your name alone?
You need to call this.
So, this certificate of service is presented to Chidera Ike Okonkwo as member planning committee for her contribution and recognition of her exceptional dedication in the success of this event today. Congratulations.
Thank you very much.
Adetola Faith Jimo. A certificate of service as well. Adetola Faith Jimo, Member Planning Committee, for your contribution and recognition of your service to the success of this event today. Congratulations. Damilola Victoria Alabi. A certificate of service presented to Damilola Victoria Alabi as Member Planning Committee for your contribution and recognition of your service to the success of today's event. Congratulations. This has to be yours. Okay. Okay. Safia Mohammed. She stepped out? Yes, someone can come and stand in her stead and... Thank you very much. Congratulations to Safia.
Okay.
I think I have to read this because she's the chair. I think I need to do this, yes. Actually, I wanted to say so. I wanted to say so. Actually. I saw what they wrote. I wanted to say chairperson, so I was going to say so. A certificate of service, MBA section on legal practice. This certificate is proudly presented to Safia Mohammed, chairperson planning committee, in recognition of exceptional dedication and invaluable contribution to the successful planning and execution of Technology Law 101, Introduction to Telecommunications and Technology Practice, held in Abuja on the 22nd day of July 2026, organized by the NBA-SLP Technology, Media and Telecommunications Committee in collaboration with Law Corridor. Congratulations.
Thank you so much, sir.
Congratulations.
Thank you, sir.
Thank you. Thank you very much. Thank you. Actually, we should have given them their own last. After it was going down, then we give him. Okay, so then.
All right. So the last set of awards, well, these are not awards in a sense. I think we'll call them appreciation tokens, or do we call them encouragement tokens? All right. So as a way to appreciate and encourage the participants at this event who were most engaging, we also have prizes for 5 people. I have 2 names here. I've been told that Mr. Henry will nominate 3 members of his team for the remaining 3 prizes. I have only 2 names here. Okay. So the first name here is Kehinde Neumatz Bemekun. Please, let's give a round of applause for her until she comes to the stage. She's been here. She came with her baby. She engaged. She asked questions. She was even punctual. Thank you so much for coming. She was number 6. Yes. Whose award are you taking? Okay.
Mr. Fernandez, I want to also add 5 copies of my textbook to that gift. So they're bringing it.
All right. Thank you so much.
Well done.
Thank you.
Okay, so I was supposed to snap picture, right?
Please, you can come this way. Yes.
Aisha will not bring the baby too.
Our youngest colleague.
Thank you so much, sir. Thank you so much.
The next person on the list is Franklin Chukunenye.
Where's the next copy? So, hold on.
I no consent to my image rights.
Hold on. So the remaining 3, I think I'll pick them by face.
Okay.
No. I'm looking for the people that were active that I think were active. Mr. Kamara has gone. Kamara is in Ogundele. No. Okay. No. Yes. No, he were active. Huh? The moderator of the session. Okay, no, please come. No, your own book. I don't think he needs your book. I think he already has it. But we'll give him my own.
The book is there.
Yes. Blessing.
Blessing already got
Yes,
one.
you already got one. Okay, Blessing. Okay. Okay, if you are not going to go, you can nominate somebody that will get it. Who do you want to nominate? Who is her? Where are they? So are we giving her your own? No, but we're supposed to give them your own now.
So there's 2 separate subjects. My intent was that.
Oh, okay. No, don't worry. When they bring it, we'll show them 2 books. So for this one, we'll snap.
This way. Come this way. I'm in the background. This is the background. Yes.
Are you not afraid of pictures?
No.
I don't like just background. You like background photos. Okay, so there's one more, right? No, it's 10. That's 11. So there's one more. Huh?
One more.
No, one more person. Somebody should call one person's name. Moro. Thank you. So Moro. Okay, so there's another set.
No. What he's saying is to keep it together.
The same persons who are getting yours should also
get this.
Okay, so I come out. All right. Everybody that has gotten a gift from the last 5 people, please come. Yeah, start with the other book. Okay. So we'll take a picture. We'll hold the two of them.
The authors.
Yes, with the others. Okay, there's one person more. Yes.
Please, let's go this way. Just
I feel this somehow. This book is so big. Yes, I'm intimidated.
Can you write more?
Eh?
Can you write more?
No, my next book is going to be bigger.
The next one will be on space law.
No, actually, artificial intelligence. Just artificial intelligence. It's ready, just the publisher.
Thank you so much. We also have virtual certificates of participation for everyone who attended today. It will be sent to your email addresses. We've now come to the last item on the agenda. And before I call on the chairperson of the organizing committee, I'd like to make a quick announcement. As soon as she's done with her closing remarks, when we leave the hall, please let's all use this particular exit. When you go downstairs, your food and refreshment or the refreshment pack will be waiting for you downstairs. If you use the other door, there's no refreshment there. The refreshment is through this door. Please don't forget. All right. So to give the closing remarks for what has been a very engaging session, I'd like to call on stage Ms. Safia Mohammed, who is the chairperson of the planning committee for this Technology 101 symposium. Please give her a round of applause as she comes on stage.
Good afternoon again, everyone. It has been a day. It really has been a day of learning and networking. I see a lot of us have laughed, we've cheered up. Some of us haven't laughed really as much as we have all through the week. So it's been good to be here. And again, I say thank you to all of us. As we bring today's program to a close, I want to thank you all for the quality of your engagement, particularly for our speakers, from the first speaker, Mr. Adet Hamu, to Ms. Antonia, to Mr. Edet, and Mr. Ajibola, who have gone through this session, and we have left. A lot of us did not have any background, but now we know what steps to take. We know the regulatory mapping. We know what interconnectivity agreement is. We know what we should do. And I'll leave you with something today. Technology and telecommunications law remain one of the least populated areas of practice within the Nigerian legal practice. And this is not because it is not important. No, rather it is because it is least saturated. And that's because a lot of us do not know our way within this framework. And today, I believe some of us know where to start from. And even if we do not know where to start from, we know who to call up to. We know where to get the resource that we need. And I tell you that the Technology, Media, and Telecommunications Committee is where you can get this resource. You have seen a lot of us. You have met us. If you have any questions, any query, you can always engage with any of us. If we do not know, just like it was earlier mentioned, a good lawyer is not one who knows all the law, but knows where to find it. So if we do not know, we can recommend within our networks where to get the resources you need. And I'll say to you something. We know that technology, telecommunications is the bane of everything. Every day we use data. I know that within this hall, I've used at least 3 networks because I needed to get connected to the world. I needed to get connected to the world. I needed to get connected to my finance, my money. So I know that I always need telecommunications and technology. And I would say that as lawyers here, we are not here just for today, but we are here for the future. And so the lawyer that is futuristic, the lawyer that is looking at the future knows that he should not be left behind. And not being left behind means you should start today. Starting today means you should embrace not just technology, but technology practice. Mr. Edet has told us that there's going to be electronic invoicing. Now, as lawyers that are futuristic, we know that that is the way to go. We know that that is something we need to key into now, not when the regulation comes, but right now. So I'll leave you with this charge. And I encourage all of you that today is not the end of an introduction. Rather, today calls you to deep dive into this aspect of law. And not just deep dive guidedly, meaning know the right courses. And from what we have done today, I believe and honestly believe that you know where to go. You know the resources, you know the resource persons, you know the regulatory framework. So I say thank you to all of you, dear participants, that have stayed from the beginning to the end. And before I close, I would specially thank the committee, from I Am Fair to Usman, to Adetola, to Chidera, and particularly our Honorable Damilola, who has been running physically. She's been doing everything. She's been running virtually. She's been running physically. If you see her, Damilola, please, I need you all to clap for her because she has done so well for this conference. She has made it easy. So Damilola, rise and get your ovation. Take your flowers. Take your flowers. You deserve it. This is, if you've been seeing Damilola Alabi, Damilola Victoria Alabi, this is the one person. She's been running behind the scene, and she doesn't just run behind the scene. She runs behind the scene, in the scene, after the scene. And so, Damilola, after the scene, we are still seeing you. Thank you for sticking around. And of course, thank you is never too much, right? Thank you is never too much. So I will thank Law Corridor, Mr. Henry, Mr. Ajibola, Ms. Kende, Mr. Ahmed, Ms. Blessing, and our own dear Sunday. Thank you for all the support. Thank you for making this easy. Thank you for your hospitality. We thank you, and I would encourage all of us to please engage with the SLP, engage with the section's activity. Now for the TMT, which is the Technology, Telecommunications, and Media, we run weekly Thursdays programs. So I would encourage all of you to join. Don't just join, engage and join any of the committees. So thank you so much for being here, and I look forward to seeing all of you on different platforms. Thank you.
All right. So I've been told that we should please wait for 1 minute. So you know that the occasion cannot be complete until the content has been cooked. So our content creator has informed me that you should please sit down, arrange yourselves, put yourselves together, arrange your suits, do like this. Yes. Do like this. Good. I'm seeing some people crossing their legs. Very good. Wonderful. Yeah. Look around you. If there's anything that is unseeming, just put it down. There's one certificate that is turned to the back. Do you want to turn it to the front so we can see? All right. Please, steeze and composure. Okay. So when the content creator comes on stage, she's going to shout. She says you should shout, thank you, NBA-SLP. Right? Thank you for attending NBA-SLP. No, now they cannot thank you. They will say thank you to NBA-SLP. Okay. All right. So when she starts fiddling with her phone, you know what to say. What do we say? Thank you, NBA-SLP. Please, as loud as you can, so we can do this once and we can start going home. All right? Okay. Thank you all so much for indulging in that. Thank you. So please remember to go through this exit so you can collect your refreshments. And we're taking a family picture downstairs, please.
For the first time, God is in your mind. People come, people judge, people go. Some will say it's each one to his own. If you go naive, you go no. Let bygone be gone.
Our studio, we thank you as well. Mr. Juwon, Mr. Sam, Mr. Victor, we thank you all.
Shall be without a face.
Yeah, our studio people, we have to appreciate them too. Someone came all the way from Minna for this event. Thank you for coming. All the way from Minna, Niger State. Thank you, Marisa Farida, for going out.
For the first time, God is in your mind. In your mind. I love to be all that you want me to be, but I'm not the same man that I used to be. Many times I ask myself the question why. Why you there when you smile, it makes me wonder why. Oh, I know it's hard to walk away from what you know. Ooh, baby, if you ask me, I'll deny. But the truth, girl, it's in my eyes. I just think about your smile. I know the child. I'm loving you. You're loving him. If you were mine, baby, if you were mine, I sure to find low, really to find low again. If you were mine. So many times I ask myself the question why. The way I feel it makes me touch the sky. I told you, I'm in love. From the madness and the pain, I'll set you free. Ooh, baby, if you ask me, I'll deny. But the truth, girl, it's in my eyes. I just think about your smile. I know the child. I'm loving you. You're loving him. If you were mine, baby, if you were mine, I saw too fine, long more, he lay too fine, long more, yeah. If you were mine, I don't wanna live without you, baby. And I wanna be your man while you acting shady. Girl, I'll go anywhere that you want. Baby, tell me where you want me to. Ooh, baby, yeah, whoa, yeah, yeah. If you were mine, if you get drunk, baby, like see.